Your Lordship, with your Lordship's kindly, at the cost of sounding preposterous, Your Lordship, item number 66 of Your Lordship's daily list, Lordship was pleased to fix it at 3 o'clock. I'm given to understand Your Lordship has another bench from 2:45. Your Lordship, I am only requesting, I am also aware Your Lordship is probably not there weeks onwards. Your Lordship, I'm only praying if it can be taken, it's only fixed for our reply. Mr. Rotnanko Banerjee was addressing Your Lordship. We would have given up our chance of reply, Your Lordship. Just that certain overruled judgments have been shown. Just to bring that to Your Lordship's notice, 5 minutes.
My Lord, I appear on behalf of the respondent, main respondent, my Lord, Rian Watertech. In this matter was fixed today as correctly submitted by my learned friend. But my Lord, I leave it upon Your Lordship, my Lord.
Even I leave it upon Your Lordship, of
will
course.
not be able to bring it forward because
My Lord.
this is the time fixed in the
Order, I do realize,
My
Your
Lord.
Lordship. Only problem,
Let us see if after the division bench is over, I don't know.
Your Lordship,
My Lord,
at
we'll
the
take
cost
our
of being
chance.
severely reprimanded, Your Lordship, and I would not have pressed this much, Your Lordship will just kindly appreciate, Your Lordship, probably there wouldn't be any time. Tomorrow, Your Lordship, Mr. Jishnu Chaudhary is appearing is not available. I do admit Your Lordship's conveniences at the...
My Lord, Mr. Jishnu Chaudhary is for them. Mr. Rotnanko Banerjee is...
No, Your Lordship, I appreciate, Your Lordship.
Indicate an appropriate time may not be possible before I return. Let us see. I'll try.
No,
My
Your
Lord.
Lordship, I will. Of course, Your Lordship.
My Lord, only one request. I have, after getting the notice at 2 p.m., 2 a.m. in the night,
Nothing will
my
happen.
Lord, only 3 dates are
nothing-
difficult for us, my Lord. Monday,
Say it
27th.
when the matter is called on, not at
My
the
Lord,
time.
this is for upgradation. My Lord, this is for upgradation.
Upgradation, please give your grounds and hand up. Hand up after writing your grounds.
May I just indicate one thing, my
List
Lord?
call করে দিন, list call করুন।
Millards, just 10 seconds, because I seek your lordship in this
Millards,
for 10 seconds. Millards, I am a senior citizen. Deed executed by me
Sir,
was...
please write your grounds of urgency and give it. I will not make an exception. Everybody is following that.
I'll do that.
And substitution petition has been rejected for upgradation.
What did I say? Please write your grounds of urgency and mention. Yes. এটা কি হলো? এটা owners
Lordship, item number 1, I'm up. Yes, Your Lordship.
লিখেন।
Affidavit of service, Your Lordship.
Affidavit of service filed in terms of the order dated
Lord, I am for the petitioner. My Lord, this matter, my Lord, High Court Legal Service Committee, my Lord, engaged me. I have filed this matter. My Lord, your Lordship disposed on 25th March. But my Lord, advocate names, my Lord, those names have been recorded. My Lord, they are no way connected in this matter. My Lord.
Very well. So what is your name? You give your name.
Yes, yes.
लिखे दिए। This matter has been mentioned.
My name is Gaurango Kumar Das.
Full stop. Mr. Das. Mr. Gaurango Kumar Das, learned advocate appearing for the petitioner, submits that the names of the learned advocates appearing for the petitioner have been uh, wrongly mentioned in the order dated March 25, 2026, full stop, as requested, comma, let the name of Mr. Gourango Kumar Das be recorded as the learned advocate appearing for the petitioner in the order dated March 25, 2026. Upon deleting the names.
Only not today, my lord. Oh, otherwise my pass over, my lord. Not today. Okay. Okay.
The supplementary, my advocate on record, I believe, has not reached as of. The supplementary affidavit has been made ready. It will be filed, in some time. Now, in respect of the submissions made, yes. And this is the affidavit of service, the fact that it has been served upon the opposite parties, Yes. So, there had been 2 occasions when the interim order had been extended. Now, on the
it's that matter in which initially your lordship will recollect it. There was ad interim order by appellate court. My learned friend challenged whether the suit is barred under the. Yes. Court should have. But
And-
the person who has invoked civil court, your lordship is.
In fact, in that case, I am in fact fortified by the provisions laid down in law, because Section 430 of the Companies Act makes it clear that any action taken by the company law tribunal, or in terms, I'll just place once Section 430 read with Section 231 of the Insolvency and Bankruptcy Code, because that is what will allay all the doubts, because I wouldn't be joining issues insofar as embassy is concerned. But when the statute itself, as has fallen from your.
Gujarat was cited by them.
No.
Did they cite it? It fell from your lordship. May I know the citation? Your lordship may kindly that citation of Gujarat just now, which, because I understand that was not cited by my learned friend, but your lordship has taken trouble anyway. I must look it. 2021 7 SCC 209. Then, my lord, without
In fact,
your lordship's time, any day I will go through that, because my understanding.
Very well, then I'll not open up my defense as of.
I don't think it's
Very
necessary, because a purely question of law. Because my understanding is the exclusion of jurisdiction is only Monday, no? Oh, Monday something that no court or likely any day except Monday. Possibly, I do not know that they are trying not to attend court. Your lordship's view is that third party remedy who is affected, his remedy will also lie before NCA. That I need to examine. Because
Absolutely. Absolutely.
I will go through that, whether third party's remedy lies there or not. If it lies, now, my lord, one thing which I do not know whether it has been taken into consideration in that or not, because if a third party simpliciter files a suit that he will not be evicted without due course of law, he is a in that case which is falling from your lordship, the relief which I am seeking before the civil court, the tribunal must be clothed with power to grant it. If the tribunal, yes, if the tribunal is clothed with the power to grant it, then now the other judgments are on the line that so far as the power conferred by liquidator,
Because the provisions of law.
I will try, but the other judgment where it was not accepted, your lordship's view is that third party's remedy before the civil court, the tribunal has power to do that. I will examine. I am saved and it is clothed with power, then possibly. No, the difficulty comes in whatever the power NCLT do have, best with the liquidator. Yes, but
Whether the powers which the liquidator can exercise is laid down under the law.
entire power tribunal do have goes to the liquidator. Therefore, it must anyway.
And there's one more thing, Malad. In the event, Malad, the matter does not get taken up because of the resolution, may it retain it's fairly appearing at the top, Malad.
Yes, we will to know this.
Very
Of course.
great.
Of course.
Malad, item number 5, Malad, this is that civil revision application from the order of contempt of the Learned Arbitral Tribunal, my lord, Mr. Medora. Oh, I apologize.
That your lordship, as because the mandate for filing written statement when the plaint was filed was expired and the written statement was not filed within 120 days. So filing of written statement has been expunged. After filing the additional plaint, the defendant ought to have filed within 30 days, but with recent judgment, your lordship, that time has been extended to 120 days, but only to the extent of the amended portion only. My respectful submission would be, your lordship, that only with the respect to the amended portion that has been envisaged in the amended plaint, to that extent only the additional written statement can be filed. But in this appropriate case, your lordship, I have gone through the written statement. Each and every averments have been given with respect to the plaint, original plaint that has been filed, your lordship. I have gone through one of the judgment of this honorable court, your lordship, one division bench judgment, your lordship, where it is stated that in case of
kindly see, my lord, this is the original plaint and amended plaint. One of both same.
Yes, your lordship. This 2025 SCC online Calcutta 1781, your lordship. It is a bit marked, your lordship. I am submitting from the, your lordship, comes to the 2025 SCC online Calcutta 1781. The appeals resolve the question as to whether the timeline specified in Order 8 Rule 1 as amended by the Commercial Act 2015 would apply to the timeline within which reply to the counterclaim to the written statement, sometimes also referred to as additional written statement, as to be filed by the plaintiff. The single judge declined to extend the time to file the additional written statement beyond 120 days and had rejected the application filed by the plaintiff for extension of time to file additional written statement beyond that time. I'm not going into paragraph number 3, your lordship. The averments given by senior counsel kindly comes to paragraph 5, your lordship. Mr. S.N. Mitra, senior learned counsel appearing on behalf of the appellant, has submitted that the Commercial Courts Act has not specifically dealt with the right of the plaintiff to file additional pleading. There has been no amendments to the Code of Civil Procedure as far as the time limit prescribed for filing additional written statement under the Commercial Act 2015. The learned senior counsel has referred to the amendment in Order 8 Rule 1 of CPC to show that the legislator in its wisdom has only amended the said provision, whereas the other provisions of the Code of Civil Procedure in relation to the filing of counterclaim or subsequent pleading have not been touched. Mr. Mitra submits that when the written statement is filed with the counterclaim, there is no requirement to take out a writ of summons. It was for this reason, Order 8, Rule 6(3) requires the court to fix the time which the plaintiff is required to answer the counterclaim to the defendant. It is the duty of the court to fix the time within which such pleading has to be delivered. Mr. Mitra has further submitted that when the rule is silent with regard to the time frame within which the additional pleading is required to be filed, the court has the power to enlarge the time in the event the court initially did not fix the time frame. Your Lordship kindly comes to the diagram number 14, Your Lordship. I'm sorry, paragraph number 17, Your Lordship. The written statement with counterclaim has been filed in the commercial suit. The provisions of the Commercial Courts Act 2015 is applicable with regard to the pleading and procedures to be followed as mentioned in the schedule of the Commercial Courts Act 2015. Under the schedule, various provisions of the Code of Civil Procedure was amended and are made applicable to commercial suit. One of such provisions is in respect of written statement. By reason of amendment of Order 8, Rule 1 of Code of Civil Procedure, the defendant would be required to file written statement not later than 120 days from the date of service of summons, and on expiry of 128th date from the date of service of summons, the defendant shall forfeit the right to file written statement. Now, my respectful submission, Your Lordship, as because on the first occasion, he has summons, and defendant forfeit the right to file written statement, and the court shall not be allowed to allow the written statement to be taken on record. Although the other provisions of the Code of Civil Procedure have not been
2, 2, 5, 2, 3, 4.
Others have filed their written statement. Your Lordship.
Other one malad SR, till malad SR, defendant number.
Your Lordship,
We already file a written statement.
No, Your Lordship.
But because malad after filing the plain, they file an amendment. Malad kindly see the amendment malad the plain. There is how you might call difference. Because the amendment is going on, all pleadings amended. Kindly see the amended plain. Kindly see amended plain and earlier plain. This is the amendment. This is amended plain, and earlier this is the. This is the original plain. Documents relying on amended plain also the same.
Your lordship, may I place, your lordship? May I place? Only, yes, yes, your lordship, only to the extent of the amended portion only, lordship, because as
Summer 23, my lord. My lord,
has
because,
lapsed
my lord,
on
when
15
my lord,
November.
when, my lord, just. Yeah, but because, my lord, the amendment file. But there is no difference, my lord, the amended, kindly see, my lord, the plain and amended plain, if there is any difference. But additional written statement, additional, the kindly see that. Yes, I file a written statement on only amendment. Kindly see the amended plain. But I only developed the defense, my lord, regarding amended plain. Bas. Kindly see the amended plaint and earlier plaint.
Lordship, I have the petition under which Order 6 Rule 17, where we have categorically stated in schedule the amended portions. That thing is there, your lordship, but I have seen their written statement also, your lordship, that they have stated in all the paragraph. If your lordship come to their written statement, in each paragraph has been dealt. Each and every paragraph has been dealt, your lordship. Para 1 has been dealt, para 2 has been dealt. Yes, lordship. Properly stitched, your lordship. And yeah.
Right. Then they allow to additional written dealt with. Number one, court directed to file a written statement on 27th March 2025. But earlier directions. No. Kindly see the earlier order. That is the direction. Kindly see the order. File a written statement on 27/3. And also, yes, and order 8, rule 10 says when any party for whom a written statement is required under rule 1 and rule 9 fail to present the same within time permitted fixed by the court, as the case may be, the court shall pronounce. But if I fail to file a written statement as per order of the court, court says file written statement on 20. Because by additional fact, but I have a defense, additional. But then, the only additional fact, can be restricted that portion can be, my defense.
Your Lordship, may I, Your Lordship, the second limb of uh, 10th of June 2025, Your Lordship. And the revision that has been filed before this.
No, I'm going to.
I am appearing on behalf of the petitioner, plaintiff petitioner. This is a suit for eviction of a licensee. If your lordship takes up the plaint, it starts from page 9. If your lordship comes to page 12, the case made out by the plaintiff is that I have granted a patta from the government. It's a homestead patta. After getting the patta, the cost schedule land out of cost schedule. Cost schedule is the structure over which the defendant is a license. But I prayed for eviction of him and necessary consequential relief. In such a suit, I obtain an order of status quo, directing both the parties to maintain till the disposal of the suit. That is now, during tendency and during subsistence of that status quo order, with regard to this core schedule, apart from core schedule where there is already a structure, they are trying to raise construction over the same. That prompted me to file an application for local inspection. That local inspection application, I prayed whether there is a new construction carried out by the defendant or not, and the local features. By the order impugned, if your lordship takes up, the learned trial judge allowed the application in part, holding that yes, if only the local features which will be identified by the advocate commissioner. But with regard to point number 2, that is the crucial, that has not been granted. If your lordship takes up the order 39 rule 7 application, that your lordship will get from page 23 onwards. The schedule is at page 24. Point number 2, I pray, because that is the important, whether any new construction is being carrying out by the defendant or not. Your lordship is not audible.
Mission work has been done or not? Because the order is of
not yet been done. That's where I am on. If it is done in a half-hearted manner, then only the local features will come. The commissioner will not point out with regard to point number 2. So I am not praying, it's my suit. I am not praying for stay of the all further proceeding. Your lordship, for the time being, just stay the operation of the order for some time, so that it can be done by
this
one
revisional
vote.
application is directed against an order dated January 8, 20, sorry, December 10, 2025, passed by the learned civil judge within bracket junior division, Jhargram, whereby the petitioner's application under order 39 rule 7 of the Code of Civil Procedure, 1908, has been allowed in part. Full stop, paragraph. Mr. Mukherjee, learned advocate appearing for the petitioner, submits that in the suit, the petitioners had filed an application praying for an order of injunction under order 39 rule 1 and 2. The order was granted, ad interim order was granted, or it has been made absolute?
My lord, ad interim order was granted, which is still continuing.
Page 21, my lord. And the said application was pressed for ad interim orders. Full stop. It is submitted that ad interim order of injunction. Where is that order of injunction?
Page 21, my lord.
That ad interim order of injunction in the nature of status quo over the injunction na kore, ad interim order directing the parties to maintain status quo in respect of the nature and character of core and co-scheduled property was passed initially on
8 January, my lord.
January 8, 2024, and the same has been extended from time to time. This full stop, the said interim order is still subsisting. Full stop. Paragraph. Mr. Mukherjee submits that the opposite parties have started raising constructions in violation of the aforesaid ad interim order, and in such view of the matter, the petitioner filed an application under order 39 rule 7 of the code in order to bring it to the notice of the court that constructions in violation of the order of status quo were being carried out at the suit property. Full stop. By the order impugned, comma, the learned trial court has partly allowed the application for local inspection and has rejected the petitioner's prayer for inspection on the point that a new construction is being conducted at the suit property. Full stop. Paragraph. Having heard the learned advocate appearing for the petitioner and having considered the material on record, comma, this court is of the prima facie view that in cases of the present nature where violation of an ad interim order of court ad interim na kore interim order of court of an order of court korben of an order of court has been alleged, comma, request for inspection as regards the act of violation should be permitted. Full stop. In such view of the matter, comma, the operation of the order dated December 10, 2025 shall remain stayed till the end of June, 2026 or until further orders, whichever is earlier. Full stop. Paragraph. The petitioner shall serve a copy of this revisional application along with notice on the opposite parties, intimating them that the matter shall be taken up, shall be listed next in the monthly list of May 2026 as motion.
I'm grateful, Miller. I'm grateful.
We have got the order, has been uploaded, stay has been refused. And in fact, we have, it's in the process of being filed. We'll get the CO number by second half. And we are giving the presentation date on 16th April because so that the service can also be where I'm sure they will be lodging KVA. Well, this is the order, my lord, which has been passed. And 16th April has been kept, my lord, by the additional district judge for appearance in the appeal, not for hearing of the appeal also.
I'm grateful, Your Lordship.
Well, only thing, well, do I need to give the number once it is, otherwise in the presentation? Yes. We're giving 16th of April. Yes. Grateful, madam. Grateful, deeply obliged.
Grateful, Your Lordship.
Look, there's another connected matter, item number, which is with regard to the police help that was granted ex parte. That's appearing in the list as item number
199.
195.
199.
199. That may appear on 16th, my lord. Very well. Very well. Great.
Grateful.
Well, this is that matter, my lord, arising out of the, yes, my lord. Partition. My lord. Yes. 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 My lord. My lord. Yes. My lord. Yes. My lord. My lord, I bow down what has fallen from your lordship. May I, my lord, address my lord's query, my lord. My lord, the Arbitration Act, my lord, is a self-contained code. The my lord, Section 37 of the Arbitration Act, my lord, provides for what, my lord, is the limited scope of appeal to a high court or, my lord, to a principal court of ordinary jurisdiction is permitted within the four corners of the Arbitration Act, my lord. Well, it's similar to how, my lord, an appeal is a continuation of an original proceeding, my lord. The 27(5) court, my lord, upon a representation, my lord, is simply, my lord, continuing to exercise the jurisdiction of the learned tribunal. My humble understanding of the law, my lord, is that since, my lord, an arbitral tribunal is not a court, my lord, within the confines of the Contempt of Courts Act, my lord, it cannot impose punishment, my lord. It comes to a finding, my lord, that there has been contempt, my lord, and only delegates, my lord, the ministerial act of imposing punishment, my lord, to a high court or, my lord, to a court. My lord. My lord. Yes. Yes. No, my lord, because yes. For the efficaciousness of the remedy. And from yes. Yes. Malad, that is possibly last paragraph of Alka Chandelkar. Malad, that is possibly a 142 situation. Because Malad, I am only Malad being apprehensive. It says Malad in the facts. Malad, I'm grateful, Malad. Your Lordship may clarify that, Malad. That would subserve our purpose, Malad. But may I, Malad, only address on a very fundamental issue, Malad. My most humble submission, Malad, is that 227 is maintainable, Malad. There are judgments to that effect, Malad, not from an order of contempt of the tribunal, Malad, but where, Malad, an arbitral. Yes, yes, Malad. Yes. Okay, Chandelkar. I told you to get another copy. No? My lord, I don't have a copy, my lord. I remember, my lord. It says, my lord, in the facts of the. Yes. 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 Very well, my lord. I bow down, my lord. Insofar as the Delhi court's view, my lord. My lord. My lord. Yes, my yes, my lord. I have it. My lord. Para 11, my lord. This is, my lord. My lord, in the nature of. My lord, it's a teeming fiction, my lord. That orders, my lord, are treated. Last month. Yes, my lord. Yes, my lord. Yes, my lord. Once such a representation is received by this court from the arbitral tribunal, be competent in default or in contempt as if. Yes. Very well. Yes. If it's not willful or deliberate. Yes. Lord. 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 Lordship. 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 Your lordship may only clarify then the order, my lord, which is under challenge. Only one indulgence I'm seeking, your lordship, because this is a stance, my lord, that the other side will take, my lord, when I agitate these issues there, because, my lord, the limited scope of the representation is for awarding of punishment, not the finding. My lord, the proceedings are ongoing.
Yeah, the
Proceedings are ongoing before Justice Kant, my lord. I'm told, my lord, the proceedings are ongoing. Very well. Well, they will possibly not. Well, yes, well, we are agreeable to that, my lord. Your lordship, then your lordship may dispose of the application, my lord. Very well, very well.
Malad, in this revisional application is arising out of, Malad, from the Copyright Act, Malad. And there is a specific provision under Copyright Act, there must be a written agreement between the parties. Here there is no written agreement, Malad, under section 19 of the Copyright Act. Yes, yes, Malad. Malad, under Order 7, Rule 11, page 11. Order 7, Rule 11 has not been happily drafted, but I've seen that. Well, section, just section 19, mode of assignment. And previously, they filed a criminal case against the petitioner, and criminal court also held, competent criminal court held, that as because there is no agreement between the parties, therefore the criminal motion is not maintainable. Ninety. Their objection is just written objection is at page no. Order 7 Rule 11 objection দিয়েছিল কোনো objection filed করেছিল Order 7 Rule 11 no objection has been filed by so, and also my lord, there is no written agreement that written
for the petitioner, your lordship. In this matter, I am being led by my senior, Mr. Tariq Kasimuddin, who is traveling for some medical reason, your lordship. Praying for not this week, your lordship. Then your lordship may be pleased to fix a particular date.
My lord, in item 2M, my lord, I tender my unconditional apology, my lord. I have made a blunder. My lord, I have described the petitioner as a plaintiff, whereas he is the defendant. So all along your lordship kindly permit me to withdraw and get the certified copy back by giving a Xerox copy. So that's why. No, my lord. This is an expeditious disposal, but in the plaintiff, I was a defendant. Well, here I have described him as a petitioner, sorry, plaintiff. Well, the pleadings is also required to be, if
Caveat. Well, I am appearing for the petitioner that the opposite party filed a preemption case against the petition interest of the present petitioners. And the said preemption case was allowed. And thereafter, my lord, the petition interest of the petitioners filed one misappeal. Thereafter, appeal has been dismissed, my lord. Thereafter, my lord,
Milord, two.
Yes,
Milord, two things, Milord. First of all, Milord, I'm taking a technical point, Milord. The certified copy is not there of the trial court. Milord, otherwise revisional application is not maintainable. Secondly, if Milord, if it is not seen also, Milord, two primary points are there. One, whether if the entire share of a co-sharer is sold, whether preemption lies, still pending. 5 matters are there before the large judgment. Out of that, 3 is mine. I'm appearing now, Milord. After Milord Justice Shane's transfer, Milord, this bench has not been reconstituted. Second point is whether preemption is bastu in land is maintainable urban agglomeration. That is the sole point taken by my learned friend in the written statement I can place. That is also pending before. Therefore, this has to be adjourned sine time.
There is also
I am appearing on behalf of the petitioner. It is an application for expeditious disposal of the suit along with the pending interlocutory applications. My lord, the suit is for eviction and recovery of khas possession. My lord, the opening of the handwriting experts report was on 10/5/2016. My lord, thereafter the written objection for the acceptance of the report of the handwriting expert has been filed by the opposite parties on 24th August 2016, my lord. But till date that has not been accepted, my lord. That has been adjourned from time to time, my lord, on the prayer of the opposite parties. And written up, my lord, order number my lord, order number 70 is the written objection which has been filed, and on 70, my lord, 24th August 2016, the written objection has been filed. Defendant. Order number 70. Certified copy, my lord. My lord. Order number 65 is for the opening. My lord, order number 65 is for the opening. My lord. My lord, report has come, but that has not yet been accepted. Lord, next date is fixed for the evidence of the handwriting expert. Lord, for acceptance. My lord. Yes, my lord. That thereafter, lordship, the evidence of the handwriting. No, lordship. My lord, I'll take instructions on that. Evidence actually. My lord, an application under Order 6, Rule 17 is also pending. That is. My lord, but my lord, next date is fixed for
The defendants of the petitioner before a lordship in a suit for eviction under West Bengal Premises Tenancy Act. In that suit, my lord, defendants file an application for repairing of the suit premises, stating that, my lord, the floor and my lord, the wall and window doors are completely dilapidated, my lord, requires urgent repairing. And in that application, my lord, to bring on record the condition of the suit holding, my lord, they file an application under Order 39 Rule 7 for, my lord, commission by a pleader commissioner. My lord, that has been rejected on the ground that, my lord, on a previous, my lord, inspection which was held by a pleader commissioner in respect of the same said property, my lord, in the some observation came that the condition of the building is, my lord, the walls of the condition of the building is damp. My lord, it is, I've annexed the report, my lord. The observation which has come, your lordship, kindly come to page 38. That is the inspection, my lord. Your lordship will find it is 2nd day of September 2025. My lord, lordship, kindly come to page 43. The only one line observation, my lord, has come, my lord, that I have found the lordship, the last line in page 43. Lordship, got it, my lord. I have found the suit property is in good condition, but damp found in the walls of the rooms. The only, my lord, one observation came on the basis of which my entire application was decided, where I, my lord, categorically stated, my lord, the condition of the walls and, my lord, the floors and the doors, everything is, my lord, is such a dilapidated, my lord, the condition, your lordship, this is for completely different purpose. Your lordship, kindly see the pictures of the suit property for once. But at that I know, my lordship, kindly appreciate, my lord, this is for different purpose, and, my lord, the only thing, and your lordship, kindly come to my, your lordship, kindly come to my application. Lordship, kindly come to my application for that the plaintiff's application, my lord, to substantiate the case of reasonable requirement, like that, my lord, your lordship, that is in page 38. The earlier application is not presently with me. If you lordship kindly, the thing is that, my lord, that only the condition of the wall was not the ground. Lordship, kindly come to my page 23, my application for repairing. Page 23. The paragraph has not merely happily drafted, my lord, but that's true. The paragraph number 4. Now that during pendency of the lordship, the walls, my lord, the walls, the floor, and the doors, my lord. The lordship, my lord, floors, my lord, if you lordship sees the picture for once, you lord, a completely, my lord, dilapidated condition, my lord. That is, my lord, my lord, my lord, only the walls, and, my lord, the walls. But it will not prejudice the, my lord, plaintiff. My lord, your lordship expedite the suit, and that even, my lord, is a suit for eviction that will helpful for them, my lord.
Lordship, in this matter, Lordship, Mr. Amarnath Das is appearing on behalf of petitioner, Lordship. I lead by Mr. Amarnath Das, but today he has some personal difficulties, Lordship. Today he could not come to court, Lordship. Kindly make it only not today, for only today's accommodation, Lordship. Kindly, Lordship. Only not today, Lordship. Great, Lordship. And not today, not today.
May it please the Lordship, but I'm appearing for the petition in the matter. My Lord, it's essentially a petition for expeditious disposal. My Lord, what has happened here is, my Lord, expeditious disposal of a miscellaneous case which we have filed. I'll quickly indicate the, my Lord, one thing I should indicate, my Lord, the orders, this matter has been heard. My Lord, 1 minute I'll indicate what has happened here. My Lord, miscellaneous case 149 of, I'm sorry, my Lord, page 4, paragraph 4. Miscellaneous case of 149 of 2005 was filed with a prayer that the deed of trust be dissolved and the beneficiaries be resolved by an order of the court. This is the deed of trust of 1971. This was allowed by the court by an order. We come to know of this. This was filed in our name, in the name of the petitioner. We come to know of this because this was not signed by us. It's a fraudulent petition. We immediately file a petition, that's paragraph 7, where we file a petition saying that this entire action was fraudulent, and we file a petition, that's paragraph 8, miscellaneous case 402 of 2012. Paragraph 8 at page 5. This was held in our favor, and the order passed in the previous mis case was recalled by the Honorable Court. Thereafter, the other side filed a subsequent miscellaneous case, that's paragraph 9, miscellaneous case 335 of 2016, and there's a stay. This is the subject matter of the proceeding now. And now kindly see the order of this mis case, that's page 18. Your Lordship will kindly take up once, page 18. At the top, miscellaneous case 335, kindly see the number of the orders, 74, 75, it goes on in the next page, and thereafter till 83. Here what has happened, my Lord, is that the written notes have been filed, arguments concluded. That's all till March 2025. Then the learned judge demised office. Now a new judge has come, and the matter is pending. It has to be reheard. Kindly fix a time frame so that the matter is reheard and disposed.
I'm for the petitioner, Lordship. My senior is engaged in court number 28. Kindly give me a short passover.
Your Lordship, I'm praying for expeditious disposal of a partition suit, Your Lordship. Your Lordship, two suits were directed to be heard analogously, Your Lordship, and in one of the suits, Your Lordship has already passed an order. Your Lordship, if Your Lordship takes page 120.
But I have not served notice.
Your Lordship.
I appear for the opposite party.
May I-
Kindly permits me to appear online. I appear for the opposite party. If your Lordship kindly permits me to get a copy of this application and let her come back any day convenient to Lordship.
It's only for expeditious disposal. What will you do by appearing?
I'll tell your Lordship.
Let them serve a copy upon us.
I'll direct service of copy upon you, but I'm passing the order for expeditious disposal and holding it back for serving and then coming back and then passing the same order. Because
No, we are appearing for the opposite parties, Mullah.
May I?
I completely bow down, I really do not know what the amendments made therein and at whose instance this was done. So there is a
I have
discrepancy.
not had a chance
lot
to
of
place my
co-personnel.
case, Your Lordship, yet. Two orders, Your Lordship. It will make it clear. Your Lordship, page 127.
Kindly
Your Lordship,
but this is really a highly disputed matter.
please wait, please wait.
Sure.
Let her conclude.
Your Lordship, page 127. Your Lordship.
27.
Yeah, Your Lordship. Your Lordship, if Your Lordship sees the first volume, Your Lordship.
127. Yes.
Second paragraph, Your Lordship. The learned trial judge is directed to hear out both the suits, namely title suit number 58 of 202. Your Lordship, in this matter, Your Lordship has already passed an order. I'll show it next. And title number 106 of 2006. This is my suit, Your Lordship. I'm praying for similar order. Now, Your Lordship would straight away take page 137. Your Lordship, relevant is at page 139. Paragraph 10, Your Lordship.
Yes.
Your Lordship has directed that this may be heard and disposed of within 1 year. I am praying for an identical prayer in my suits as it is. Your Lordship, both has to be heard analogously.
Yes, there's no problem. I'll dispose this off, saying that it should be heard and disposed of within 1 year as already directed in CO 746.
Your Lordship.
Which is the application made by our client.
Yes, Prashant Jaiswal.
Your Lordship, it was their obligation to bring this to Your Lordship's notice that two suits have
we had
heard analogously.
Very well. It's the same thing. I'll direct.
Kindly, in that event, I'm not coming in the way. Kindly, in that event, only protects us so far as the allegations made in the
I'll say that that is in any case there. It's not a writ petition.
I know, but still.
I'll record.
Your Lordship, except for my learned friend, everybody else is ready to settle the matter, Your Lordship. Partition suit.
That's probably not true.
Only he-
That's probably not true.
That is on merits, Your Lordship.
Very well.
That's probably not true, Mullah.
This revisional application, expeditious disposal of title suit number
Your Lordship,
106. 106 of 2006. Pending before the learned civil judge within bracket senior division, second court at Howrah. Full stop. Paragraph. Ms. Chaudhary, learned advocate appearing for the petitioner, submits that the suit is one for partition. And full stop. It is submitted that another suit, being title suit number 58 of 2002, is also pending before the same learned judge, and the same had been directed to be disposed of expeditiously, preferably within a period of 1 year from the date of communication of the order dated March 5, 2026, passed in CO 746 of 2026. Full stop. Paragraph. Attention of the court is invited to an order dated April 19, 2012, passed in CO 617 of 2012, whereby a coordinate bench of this court had directed both title suit number 58 of 2002 and title suit number 106 of 2006 to be heard out analogously. Full stop. Paragraph. All the opposite parties are represented.
May I have a look at the names of the parties?
But I appear for Prashant Jaiswal and my mother, I believe,
You
Archana
appear for
Jaiswal.
Prashant Jaiswal.
Yes.
We appear for Chandra Devi Jaiswal is there. We appear for Chandra Devi and Prashant Jaiswal, right?
Chandra
They can give their names and they can say for whom they are.
The opposite party number such and such is represented through Mr. Bordhon, and the opposite party number such and such is represented through Mr. Shorkar. लिखे देबे?
We appear for the opposite parties number 1 and 2.
He is also appearing for 2.
He's with me, Mulot.
Okay. So,
Oh,
Mr.
I see. I'm sorry, but I did not know.
No, not an issue.
The opposite parties number 1 and 2 are represented through Mr. Bordhon. ঠিক আছে, তারপরে লিখুন। In view of the nature of the order proposed to be passed, prior service of notice along with revisional application is not being directed on the other opposite parties who are not represented today. However, a copy of the revisional application along with a copy of this order shall be served upon the non-appearing opposite parties within a week from date. Full stop. Paragraph. In view of the orders dated April 19, 2012 passed by this court in CO 617 of 2012 and order dated March 5, 2026 passed in CO 746 of 2026. This revisional application is disposed of by requesting the learned civil judge within brackets senior division, comma, second court at Howrah to dispose of title suit number
106 of
106 of 2006 as expeditiously as possible and preferably within a period of 1 year while trying the same analogously with title suit number 58 of 2002 as already directed by this court by the order dated April 19, 2012.
Mulot, take up page 139 for once. Mulot, there was also an order for disposal of the interlocutory applications within 8 weeks. Mulot, let that order also be complied with by the court.
My application.
That's already there. Full stop. Paragraph. CO. अच्छा तार आगे लिखे दिन. As requested by Mr. Bordhon, it is recorded that allegations made in this revisional application shall be deemed not to have been admitted since affidavits have not been invited. Full stop. CO 1181 of 2026 stands disposed of with the.
But the copy of the application is served upon us as well.
Acha, on all
the opposite parties.
Your Lordship, only on respondent number 1 and 2, Your Lordship. Your Lordship, I will serve on them.
No, others I have said you have to
Yes,
serve.
others, Your Lordship, I'll have to serve. Your Lordship.
That is a standard order.
Your Lordship. I'm grateful.
I'm so
Your
grateful,
Lordship.
Mulot.
Since I'm dispensing with
I'm
notice now, with the copy of this order, you have to serve.
I'm grateful.
Grateful, Your Lordship.
Number 18, my lord.
Why mention?
Say expeditious disposal matter, my lord. Item number 18, just.
Somebody prayed for time. 18 did.
I am praying for expeditious disposal of a title suit, my lord. Suit for declaration and final injunction.
This revisional application, item 18. This revisional application is NAISNA 6, expeditious disposal of title suit number
And this is my application, my lord. Plaintiff appellant petitioner before your lordship. Ad interim refused by the learned trial court on the ground vexatious schedule and no prima facie case. Assailed in a miscellaneous appeal, appellate court hold there is a prima facie case, but there is no urgency. Though my case is, my lord, I have, my lord, qualified, my lord, 3-pillar test, my lord. There is a apprehension of dispossession. Page 24 of my application, the plaint and the injunction application clearly demonstrated how I have been deprived. So the balance is convenience is in my favor. I am praying for a station scope, my lord. Yes, my lord, my interim protection, otherwise, my lord, then my lord, appeal be reheard, my lord, my appeal is pending, my lord. My lord, may I submit one indulgence, my lord. What happened, my lord? No, very difficult, my lord. But I do appreciate, my lord. But one thing, my lord, now this is a situation after SIR, my lord. My lord, there is a huge burden, my lord. My lord, give a specific date, my lord, within 15 days. Otherwise, my lord, it will be trouble. In Miss Appeal number 34 of 2026. 34 of 2026. Well, kindly have been go through the order input, it has been hold that there is a prima facie case. First court browser. Should for declaration and permanent injunction, declaration of my absolute right, title, interest was in respect of the suit property. Page 18 is the my lord consent statement, is lordship will find 19. Hold, there is a prima facie case. I'm grateful. No orders. Page 24 and 25 is my urgency, my lord. I have pleaded. My lord, page 24 and 25. Page 24, my lord, kindly come to page 24. Roman 11. And there's a repeated attempt of invasion, my lord. I am being dispossessed, my lord. I can be dispossessed at any time, my lord. Let's qualify the first condition of the my lord authority rule 1. Only that limited protection, only my possession. It will not harm to the opposite party. They have no locus, my lord. Deeds and all are in our names. We are residing there. My lord, plaintiff page 18. Starts from page 18, lord. No, page, sorry, my lord, page 17. No, sorry. Injunction application. My lord. Then, my lord, the injunction application. My lord, I have the copy of the print. Yes, my lord. My lord, sorry, my lord, I have the copy of the injunction application. In meantime, may I get some protection, my lord? Then, my lord, fixed a date, my lord, for hearing of this civil division. I will serve by today. May, my lord, I will be seriously prejudiced, my lord. My lord, then, my lord, this is April, my lord, and the last week of the April, my lord. May then date, fixed date, my lord. Any date. Well, can be time be fixed, my lord? My lord, it should be in the top. I'm grateful. On number is actually yes. Item actually number.
Lord, expeditious disposal of the suit and my lord along with injunction application, lords. And lords.
Rule 1 and 2 was filed, that application was allowed ex parte and the same was extended from time to time and the same is still subsisting. My lord, since the opposite parties were violating the order of injunction, my lord, I was compelled to file an application under section 151 for implementation of the order of injunction through police help. My lord, that application was filed on 2nd April 2025 and the written objection was filed on 2nd May 2025. My lord, that was not disposed of because repeated adjournments were sought for by the plaintiff. My lord, kindly comes to page 31. My lord, my lord, my lord, it was the Lordship's coordinate bench was pleased to direct the learned trial court to dispose of the application on the next date fixed. That was on 14th August 2025, my lord. Till date that is still pending, my lord. My lord, other interlocutory applications are also pending, my lord.
And for the petition, my lord, impugned order in page 23. It's passed by Learned Civil Judge, Junior Division, First Court, Shiala, in title suit 83 of 2023, my lord, by allowing the defendant the main keys of the main entrance and first floor premises. Fact of the case is, my lord, admittedly, defendant and plaintiff number 1 are co-owner of the properties. Defendant is the widow of the elder brother of the plaintiff number 1, my lord. But fact remains, defendant never stayed in that residence till the lifetime of the deceased elder brother of the plaintiff number 1, my lord. He used to stay with us. I instituted this instance to suit, praying for declaration from the Learned Trial Court for free enjoyment, peaceful enjoyment of the suit property against the defendants. Why? Defendants, despite of being not in possession, which is reflecting is one police report that defendant is trying to enter into the premises. Now, my lord, admittedly, defendant has the right in the suit property. There is no dispute. But the dispute is, my lord, in the meantime, I have instituted another partition suit. Written statement has been filed by the defendant, and defendant has instituted another suit against me for praying for declaration for having access in the property. In the same trial court, from 2 suits, my lord, one injunction was granted by the appeal court, Learned Appeal Court, with regard to status quo, and the parties were refrained from ingress of the property, and third, my lord, restrain the parties from changing nature and character, my lord. Why I am segregating these 3 parts? I'm coming to the point, my lord. Now, my lord, during pendency of this instance suit, my lord, defendant has filed an application under on the Order 39 Rule 2A, alleging that I have breached the injunction, my lord. Trial is pending of that proceeding, my lord. Defendant has come thereafter, my lord, 2 applications. One for praying for giving keys of the main entrance. 2, praying for giving keys of the first floor. From the very beginning, defendant's allegation was that she had been in possession, my lord, from the first floor, and she subsequently, allegedly, she was dispossessed, which I disputed. In my written objections of the 2 said applications, my lord, was clearly that let the partitions would be disposed of, and secondly, my lord, let the Order 39 Rule 2A application be disposed of. Because the main dispute whether she is in possession of any of the portion of the suit property or not. Because if this impugned order remains in existence, my lord, the injunction order will be frustrated. Because ingress egress is acceptable and admitted, but with regard to nature and change of nature and character, my lord, and the status quo, I am in possession, rightly or wrongly, of the entire premises. And one significant point, my lord, defendant had filed one writ petition before the Honorable Justice Tirthankar Ghosh, and while disposing that matter, annexure O, my lord, the Honorable Court was page, my lord, 124. 124. However, if already an application under Order 39 Rule 2A of the Civil Procedure Code is pending, then the parties would contest the same in the background of the present facts and circumstances of the case. However, prima facie, I do not find that the police authorities have violated the orders passed by the civil court, but if a particular portion of the property is claimed by the petitioner, that is the defendants, my lord, for possessing and enjoying the same, it would be in the interest of justice that the learned civil judge, already in assessing of the issue, would clarify and specify the same in accordance with law. So first it has to be decided. I'm not disputing her right, my lord, but first it has to be decided. My lord, another thing, my lord, kindly consider the police report, my lord. This page in is in my lord, page 89. Police report filed in an application under section 107 of CRPC. May I read the fifth paragraph, my lord? Page 89, my lord. Fifth paragraph. On the other hand, my lord, applications page 102. First, two applications are there, my lord. Annexure K and Annexure M. 102, my lord. First application. In the applications, in these two applications, my lord, the alleged date 17th February 2025, that is also disputed, my lord. Defendant in these two applications, I'm sorry, my lord. Lordship, if your Lordship kindly consider that in the two applications, the date 17th February 2025 mentioned that defendant was registered on 17th February 2025. However, in the contempt 39 order 39 rule 2A application, minors, dates are different. So the prayer was made before the learned trial court on the basis of alleged dates, that those were also self-contradictory. In fact, no advocate commission application was filed by the defendant with regard to determine the exact position of the defendant, my lord.
All throughout, been telling them.
My lord, that event, if this fallen from your lordship, then
Basically an injunction, positive injunction.
no specific prayer was with regard to that, my lord. With regard to that.
Mandate.
In that event, my lord, I will come back. In the meantime, my lord, a very short statement.
May I make this submission, my lord? It's a very small thing. My lord, admittedly, my lord, we are owners of that property, both of us, and he said that too. My lord, he is in possession of the second floor and the third floor. I have no problems with it. He has said that he is not in possession of the ground floor. I am in possession of the first floor. Now, what happens is when the main entrance has a key and the first floor flat has a key, these keys have been changed. If my learned friend can take instruction and let them stay wherever they want to, let me also stay wherever I am. And the entire matter comes to an
That
end.
is the dispute. That is the main dispute, my lord. I am in possession of the first floor and second floor.
First floor, you're not.
She
You're
was never been in
second and
possession of the first floor.
that anybody can go and see, my lord, that all my articles are.
She was never.
My husband, my mother was a cancer patient. I had to come to my mother for some time, and I would go back to my matrimonial home. That's my matrimonial home. Anyways, I have a right on that property. Divorce everything.
One
the horse, my lord, the co-sharer thing. I have a right on that property, and if my husband was alive. Well, two brothers. My husband was one brother. He passed away. Then that property will not devolved upon me and my daughter. It should be.
Petition was failed, my lord.
There is nothing in this. I think the entire suit could have been.
No. Yes, it was referred in the High Court Mediation Center, my lord. That was failed.
They admit I am 50% owner.
Yes.
If they admit I am 50% owner, then what's the point in going into a suit? You yourself tell me which part you will give me. Useless.
My lord, practical difficulty. We tried. That is why partition suit was instituted.
No, I'm saying try now.
If your lordship desires. No. We are agree, my lord. We.
My lord, he gives me my 50%, I will do nothing. He let him decide which 50% he's going to give me. Over
share is my lord.
Problem is, my lord, in the meantime, there is an injunction that my ingress and egress. Yes.
My lord, in that event, my lord. No, I have the instruction for me. My lord. My lord.
My lord. But one difficulty, my lord, in between this 1 month, the defendant will try to take the position of the first floor.
He is
on the
with
strength of
me.
this order, my lord.
Will not happen.
I agree with the 50% share, but the dispute is which portion she will enjoy. Because she
Tell
this-
me
she
that. Doesn't have to go to mediation. You tell me which 50% you will give.
I am I
No, I'll tell you, Your Lordship. He agrees to my 50%. Do not send it to mediation. Let him decide which 50% he's going to give.
Then may I suggest, my lord, one thing? If a special officer can be appointed for determining the portion, my lord, because practically the
You tell me which part of.
In fact, my lord, I agree to pay the market value amount with regard to 50% of her, because practically the property is not possible to partition. That is the difficulty.
ওখানে থাকতে চাইছিস? So I'll take instruction on that. I am told by Mr. Haldar Milord that my client has told him that she wants to go and stay there because the mother has now passed away, and but she wants to stay in her matrimonial home. So mediation, Milord, I'm saying we can be the mediators. It's not because it will take a long time there and expenditure. We can be mediators.
I agree with the mediation, but
Let him tell me, Milord, which part he's going to give.
The property.
Not next, just the week thereafter. Just the week thereafter. Keep said, Milord, I'll try and do it within this week. Your Lordship would be in. My Lord fixes it the week thereafter. If not, Your Lordship will take it up later.
But till then,
No.
order of state.
Kindly
Otherwise,
do
she will
that.
try to.
No, kindly do not do that. I'll tell Your Lordship why. I'll give Your Lordship one.
Humble submission, my lord.
If we
Because
Monday and that week, Milord, is a little difficult. Just thereafter. Hey, Monday, how can we do it tomorrow?
Tomorrow?
Monday. কেন আমি অর্ডার রয়েছে আমি এটা রিভিশনটা মেইনটেনেবল কিনা সেটাই ঠিক নেই
ওইটা একটাই ডিসপিউট পোরশন
ওটাই ডিসপিউট প্লিজ টেক ইট আমি গিভস মি 1 মিনিটস টাইম তো মার্কেলকে বল যে আমাকে কোনটা দেবে বলে দিক দেবে না বললে ওরকম গাজরি করে
পুরো প্রপার্টিটাই আছে তুমি পার্টিশন করো
গাজরি করে
ওটা পুরো পার্টিশন
গাজরি করে
আপনারা সেট করতে হবে রাজি আছে সেটাও তুমি রাজি
গাজরি করতে পারো না কারণ শো হিম আস্ক হিম টু সি রিড
আমিও ফার্স্ট ফ্লোর চাই ও ফার্স্ট ফ্লোর চাই এটাই তো ডিসপিউট
আচ্ছা ও আমি যদি গ্রাউন্ড ফ্লোর আর সেকেন্ড ফ্লোর নিই
পুরোটাই তো পজিশনে আছে ও যে অ্যাজ পার
পজিশন থাকুক সেটা তো থাকবেই পজিশনে তাই জন্য তো পার্টিশন কি বিপদ একটু কথা বল
We will come back after taking instruction.
Well, all my articles are there in the first floor flat. Everything.
That is as per your lordship's.
Very well.
But in the meantime,
then I'll have to decide. If in the meantime I have to pass something, I'll have to come to a prima facie conclusion.
She will enter the property. She has been never in the property. This is my humble submission, my lord.
Mr. Can it be, can status quo, Mr. Chatterjee, be maintained till 30th?
Let them not disallow me to enter because that's the order of injunction. That's the order of injunction. But that will be modifying the order of injunction. Have a look at 71 once. From restraining the other sides from free ingress and egress in the suit property.
Yes, if
she has entered into the premises on the ground floor, my lord. But
exactly what I'm saying. He's admitting that.
She doesn't have
admitting that
occupancy in the entire premises. Where
no. Stay on his possession, injuncts me. I will not.
Position, my lord. That is the only dispute, my lord.
Property is what?
Is a house.
What has happened?
It's a 4-storied building. He wants to enjoy 4 stories.
Property is open for all of you then.
Yes, my lord. But where she
that is
will
what
stay,
the order of injunction is.
That is why partition. If
and does the court say who is in possession of?
No, never, my lord.
How will the status be determined? Status quo order. How will the status be determined? Who is in possession of which portion? That is clear.
This report is there that she had never been in possession. That was not challenged, my lord.
That is not a part of the trial court's records. I did not say anything to my learned friend, could not have even looked into that.
my written objection. That was filed in my written objection. And I have mentioned in my written objection. He was never been in possession. If your lordship allows this impugned order, my lord, my partition suit will be frustrated, my lord.
My lord, kindly have a look at 114 once. Yes, and kindly see paragraph 6.
Yes.
That the defendants begs to submit that before the death of her husband Kollan Dev, the defendant along with her deceased husband and minor daughter were in exclusive possession of the first floor flat.
This is
So is there any finding to this effect by the learned
This is
trial?
her admission, their admission.
This is her application, ma'am.
No, this is your application. Is there any finding to this effect by the learned trial court?
Yes, yes, yes.
Is
Yes.
there any finding to this effect or
No.
No reason
Nowhere.
order was there, my
But
lord.
admittedly, my lord, the first floor flat, the keys, everything belonged to us. They were in occupation of second and third.
Mr. Chatterjee, where do I get that from a court?
Now, from the
Yes,
court
my-
finding, my lord, it's difficult. Only one finding is that there will be no problem with ingress and egress.
That is why I submitted before your lordships that no advocate commission was prayed, application was prayed for by the defendant to determine her exact position, my lord. The only issue is whether she has been at all in possession of any portion of the property or not. My partition suit will be frustrated, my lord.
No,
This will sustain, my lord.
No.
In fact,
No, that's not
in
correct.
fact, my lord, the defendant
That's not correct.
is in the cross-examination of the Order 39 Rule 2A application where she has been submitting many self-contradictory statements, my lord.
No, whatever be the self-contradictory statements, it's an admitted
This
fact.
title suit number 83 of 2023 was filed by you. What was your averment in that title suit with regard to the first floor flat?
That is in my position, my lord. Throughout the litigations, each and every litigation, my lord, I have stated that I am in position, my lord. The title suit was instituted on
Please, paragraph 4.
Yes, that is the main dispute.
3 and 4.
She is trying to enter and disposes me from first floor, my lord.
Paragraph?
Paragraph 4, my lord. Paragraph 4. Paragraph 4, page 25.
Not first floor, third floor. Page 25.
Kindly consider the entire paragraph.
Of course. Good, bad, indifferent below, they have admitted that I have entered the premises.
Yes. I'm not denying that.
And it can't be,
That
Lord.
is
I
the
am a
main
co-sharer. How can you stop me from entering? May I ask this question?
I do not want to stop the defendant, my lord, but let it be first determine her actual position or whether she is in position or not at all.
And I can show your lordship one more very important part, my lord, why I say that I was in possession and they admit it. In the partition suit, I'm sorry.
Yes.
In the partition suit, your lordship knows, my lord, court fees are being paid, my lord, in two different ways. When a co-sharer is in possession, my lord, always a fixed court fee is paid. But if he is not in possession, my lord, then, my lord, the court fee is ad valorem. Here, my lord, a fixed court fee has been paid.
Yes.
And the suit has been valued at 400. So that itself is a pointer, my lord, that he admits I am in possession. In the partition suit. So whatever it is, my lord, you can't, if I am not in possession, then why will you even say that I've entered the premises?
Very well, let me consider tomorrow.
And I firmly believe this is not maintenance.
Very technical point.
It is. Nowadays, my lord, there is a judgment of Justice Rai which says if there is a natural justice violation, it becomes revisable, but others have differed. But it's a weird place, my lord, that we are in.
62 or 63 is the earliest
Yes.
in point, which says, which differentiates between an
Justice Bhaskar
injunction.
Bhattacharya was very clear that even if it's 151 and if there is a prayer,
51 is permissible in terms that Mohinder or something, 60,
Yes, yes,
62 or 63, where it was said
based
that
on that,
it
that's
should be
the fair-
something, it should be something which is beyond 39 and 94,
my lord.
which this,
But even then, if the prayer is that of injunction, then it will be appealable.
Yes.
The nomenclature doesn't matter.
then thereafter,
That's it.
our
Bhaskar
division bench, our division bench,
Justice Bhaskar Bhattacharya, Justice Shubhra Kamal Mukherjee, Justice Jyotirmoy Bhattacharya, everyone, my lord, has made this.
In that event, my lord, with
Justice M. Bhattacharya is that
Bhattacharya,
division bench judgment.
Plenty. Whoever sat my lord in the civil determination have passed that judgment. That is,
लिखे नहीं काल के रखे.
I mean, I have my lords kindly.
Heard Mr. Mitro, learned advocate appearing for the petitioner, and Mr. Chatterjee, learned senior advocate appearing.
Of the predecessor in interest of the defendant. In the year 1983, at the time of loan transaction, an agreement was entered into in the year 1983. Thereafter, my client was put into position since December 1983 with a liberty to carry on business of hosiery goods in this shop room with the knowledge and consent of the superior landlord. Since then, my client, the petitioner's husband, the predecessor was carrying on the business of hosiery goods. After his death, when the petitioner before lordship started carrying on such business in the suit shop group, the predecessor in interest and title of the defendants of the opposite party, they came forward and started creating disturbance and tried to out her from forcible position of the support. He filed a suit with a prayer for permanent injunction not to create disturbance. On receipt of service of summons, the defendants entered appearance and filed written statement with counterclaim. In the counterclaim, they took the plea that no, you are a mere license in respect of the suit property. License has already been revoked, so you please quit and vacate. Ultimately, upon contested hearing, suit was decreed. Counterclaim was allowed, my suit dismissed. Appeal was preferred. In connection with that appeal, an application for stay was filed, along with an application for appointment of a special officer for determining the quantum of the occupational charges. By the impugn order, the learned judge allowed this stay application without taking into consideration my application for appointment of special officer, and thereby directing my client to pay rupees. Actually, the amount of rent was 300. Contractual rent, and instead of that, my client has been directed to pay an exorbitant amount of 18,000 per month towards occupational charge.
What is the extent of the area under your consideration?
Area 250 square feet.
Place, where is the place?
Place Arjikar Road in North Calcutta. A small shop room dealing with hosiery goods, very small, and my client, the people, dear lordship, the petitioner of your lordship, widowed lady, having no male member, helpless lady, she has been somehow earning her livelihood with the meager income of that business. 18,000 is too much. That was not at all considered, and the application for appointment of special officer was also not taken into consideration. Only this is the only grievance. She is not in a position to pay such a huge amount. Well, after the Atmaram's case, you also know 2008 volume 7. The Supreme Court is the Supreme judgment held by the Honorable Court. The amount of occupation charges must be reasonable. It must not be oppressive. To show our bona fide, file that application for appointment of special officer. But that was not taken into consideration.
Did they file an application for occupation charges, or the court has of its own done it?
Only court against our stay at the time of upon hearing my application for stay, the court passed the order.
When is the next date for execution?
For execution, execution had this state. Tomorrow, I think, the date of hearing of the appeal. Execution proceeding has been stayed.
Tomorrow is the date for receiving
hearing of appeal.
Very well. You serve and come. I will not stay execution because I must hear them.
All right, all
right. This revisional application is directed against an
Lord, my senior Mr. Partho Putimra is currently out of station. So I'm kindly praying for not today. Not today.
And I'm for the opposite party.
Not
25 and 27.
25 and 27.
Not today করে দিন 27 টাও not today করে দিন
Lord, matter is about disposal of the suit.
This revisional application
my lord. The opposite party preemptive, my lord. Section 8 application under Land Reforms Act, my lord. The first court holds in my favor, dismisses the application on the ground that the entire share of the, my lord, the owner has been transferred. This was reversed by the appellate court, my lord.
That reference is resolved.
Pending. And that apart, my lord.
Oh, yes. Today morning only he said.
Yes. So it's pending. So, my lord, then that apart, if your lordship sees that those were the points for determination before the appellate court. The appellate court
It will require hearing, Mr.
Yes, Mr.
Serve notice, come back.
I need a order of stay, my lord.
What stay? You have come up
kindly
after 2
cease.
years.
No, my lord, I have come up because, my lord, kindly cease. I applied for the certified copy within time. The certified copy was granted, my lord, given to me after 7 months.
And even thereafter you have come.
1 month thereafter, my lord, have come, my lord.
Very well, serve and come. Stay after they appear. I'll fix a short date. For all these days, nothing has happened, nothing now. This revisional application is directed against an order dated December 24, 2024, passed by
time to time. One occasion, my lord, I could not file, the advocate could not file the application for extension of interim orders due to the misposting on the part of the clerk in the diary of the advocate. Now, my lord, the court vacated the interim order. Now, my lord, we filed a show cause on the 2 or 3 days after. Now, my lord, that show cause application has been rejected on the ground that court's diary was rightly posted. Why should I give you that leverage? Our show cause, but the advocate's diary was misposted. Kindly see the order, my lord, 21st August. Kindly see, the plaintiff has filed a petition stating that he has filed a petition for extension of ad interim order of injunction on 17 March 2025 due to misposting. They have failed to take proper steps on 3rd May 2025 and the order of ad interim injunction stands vacated on the day. The plaintiff has filed this petition recall of the said order dated 3rd May 2025. Defendant has filed objection and stated that the petition is misconceived. It appears from the record that the date is 3rd May 2020 was correctly mentioned
in court's diary as well as in the cause list and CIS. Hence, the petition for recall is rejected. My show cause was it was misposted in the diary of the advocate. I did not levy any allegation against the court. Kindly, my lord, fixes it next week. My lord, partition suit, injunction, my lord.
This revisional application is directed against an order dated August 21, 2025, passed by the learned civil judge within bracket senior division, first court, Howrah, whereby the petitioner's application for recalling of an order dated May 3, 2025.
May 3 is previous page.
The order is also of August, May 3, 2025. Little
Look, I want to mention one item. I understand that it has been mentioned in the morning, my lords. It is for 3 p.m. that rain water tech.
Don't mention now, it has been done. Call for only.
That's the only difficulty is I have to travel from Delhi. So, my lords, it may be kept tomorrow if possible, my lords, at any time.
Not possible tomorrow. You will get a date.
Lordship, item number 107, Mr. Shiva Prasad Ghosh is appearing. Lordship, he is not present in court today due to some personal
Not
difficulties.
today.
Grateful.
Next.
My lord, in this matter, item number 107, 108, 109 is similar with the item number 755 of monthly list. All
8, 9,
four,
10, not
8,
107.
9 are different.
beg your
My lord, 108, 109 and 110, we are appearing for the petitioners filing the affidavit of service, my lords.
Yes.
I'm appearing for all the respondents. This, all three matters are common with one of the matter, that is 755 of the monthly list. So it may be tagged, that 755 of the monthly list be tagged with all these three matters.
My lords, I'm being led by a senior counsel appearing from Delhi. Any date may be fixed. He will appear and address your
All
lordship.
are arising from the same order, my lord.
Or common order.
Common order.
My lords, any date.
Yeah, give me a date.
My lords, any date convenient to your lordships.
Suggest. Both of you suggest.
Their convenience, because coming from outside the learned council.
What is the issue?
The issue, my lord, is that the NCDRC has passed an order sitting singly in the appeal of the petitioners. The appeal is arising out of the order passed by the State District Judicial Commission, under which they challenge the limitation, that the commission have not dealt with the limitation issue. And that particular issue was dealt with the NCDRC sitting singly. This is the only issue, and
But
with
that
very
is
fair.
not settled.
My lords, it is
It's in
settled
the,
that NCDRC cannot.
Forum non-judice.
Yes.
Yes, my lords.
The only thing is that
it has to go back.
Yes,
there.
it has to go back.
Yes. My lords,
We
any
also
date.
find that is.
My lords,
Then
8
we
May.
can pass that order
Yes.
even today.
My lords, my senior will address your lordships once.
On what he is also agreeable.
My lords, please let him address your lordships.
Was in
We're under
very fairly submitted the.
Absolutely right. He's right, because in the I went through the earlier order passed by this court, where a judgment of the Honorable Supreme Court was cited when stay was granted.
Yes.
After that, what remains?
My lords, can we seek a passover? We can come back with instructions.
Passover.
My lords, 109 and 110 affidavit of service.
So don't file affidavit now, since it's Passover, passing any order. Next. ঠিক আছে বলছি।
May it please your lordship. My lord, I am for the petitioner, my lord.
Who is appearing for the opposite party?
My lord, this is the, my lord, affidavit of service, my lord. Service has been effected to all the opposite parties, my lord. My lord, the case, my lord, relates to, my lord, the petitioner being the plaintiff filed one suit for declaration and injunction against the present opposite party defendant in the court below, trial court below. My lord, seeking for injunction restraining the opposite party defendant from changing the nature and character of co-scheduled property. Co-scheduled property is the exclusive plaintiff's property, wherein, my lord, defendants present opposite parties are stranger. My lord, kindly come to my against that contested injunction order, my lord, the defendant, my lord, preferred on misappeal. Misappellate court, after my lord contested hearing, my lord, it was held that since in the court below granted injunction, my lord, against a co-owner, held that the opposite party defendant or co-owner in the state of suit property by ignoring the nature of documents they relied on. My lord, what happened, my lord, do you know, my lord, under Mohammedan law, my lord, APDC's son of a person, my lord, his legal heirs can't have any right over the property of a person. But suppose A having a son died prior to A. So the legal heirs of the predeceased son can't be claimed as heirship. My lord, kindly have a look, my lord, the order impugned first, my lord. My lord, kindly come to my lord, order impugned. But since it is a longish order, I my lord, place my lord, relevant portion, my lord. My lord,
Let me go through the order.
my lord.
Lordship, kindly came to the appeal order, Lordship.
Joshua orderটা দেখছি, সেটাই দেখছি।
Yes, Lordship.
Please take your seats. I'll read it.
Thank you. My lord, Xerox copy probably, my lord, is annexed, my lord. Certified copy, my lord, not annexed, my lord. No, 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 order is not annexed, my lord. My lord, kindly see, my lord, here, my lord, the first paragraph of this judgment, my lord, it says, my lord, that order, my lord, relates to defendant not to change the nature and character of the suit power till disposal of the suit. That much. Injunction in respect of not to change the nature and because
Lordship, trial
not
court order,
13.
trial court order is also annexed, Lordship.
Oh, 51, 51. Sorry, my lord. 51. ভুলে গেছি। Yes. My lord, in trial court, my lord, order, my lord, your lordship gone through this, my lord. First, second, considering the facts and circumstances, facts and the documents of the suit, the defendant had stated that they had been gifted the suit property by Ishaq Ali. Ishaq Ali means their grandfather, because their father predeceased Ishaq Ali. By deed of gift deed being number such and such filed by the defendant. But it can be found from the written objection of the defendant that he had stated that the defendant had received the property from Ishaq Ali in the year 1996. In the year 1996, gift deed of 2004. Thus, the deed and the statement mentioned in the written objection are becoming contradictory on behalf of the defendant. Whereas the plaintiff had stated that they had inherited the property from Sheikh Ilyas, and Sheikh Ilyas had received the property from Ishaq Ali. Right? Nirupam deed, it is undisputed. That is way back in 1963. So, in my plane, in core schedule, there are only, my lord, 63 decimals of property, my lord, in different dag number, which we obtained from, my lord, 1963 Nirupam deed, and some portion on the death of, my lord, this gentleman, my lord, Ishaq Ali, on October 2013. October 2013, because under Mohammedan law, PDC's son and his heirs have no right over the property left by the person, Ishaq Ali. So, on the death of Ishaq Ali, his wife, Fuljan Bewa, and his brothers and sister will get his property. So, out of constitutional property, 63 decimals of property, we plaintiffs got some property by way of Nirupam deed in 1963, undisputed, and some on the death of this Ishaq Ali in 2013. My lord, up to 2022, there was no dispute. We enjoyed the property peacefully. In 2022, the grandson of this Ishaq Ali, they are claiming, they are disputing our right, and they obtain, my lord, their name recorded in the record of rights on the basis of, my lord, inheritance. But kindly have a look. In one hand, in trial court, it is their case that they obtain the property through, my lord, they obtain the property through deed. And on the other hand, it is, my lord, your lordship will find it.
It is the subject matter of the trial court, lordship. But injunction we.
আমি complete করিনি, my lord. In the my lord appellate courts, my lord, in this portion, my lord, kindly have a look. I am showing, my lord. My lord, my lord, running page, my lord, it is mark kora nei re. 1, 2, 3, 4. My lord, Nirupam deed we have not, my lord, annexed, my lord. Nirupam deed, my lord, no. Nirupam deed, my lord, it is not disputed. Yes, my lord. My lord, in my lord, appellate court judgment, my lord, Nirupam deed, he, my lord, dealt with, my lord, he speaks about the Nirupam deed, my lord. That is, my lord, in page, my lord, I am showing, my lord. But, my lord, kindly see, that is there, my lord, and kindly see this, my lord, their claim of that they are recorded in 2022 on the basis of inheritance. So, in one hand, they are saying deed of gift dated 2004, and also said in trial court that they got the property sometime in 1996. Contradiction. And appellate court, my lord, they are claiming that Muhammad Ishaq, my lord, is certified that the following persons are the legal heirs, all the grandson. If there is any deed of gift in favor of grandson, then why the grandson will claim the property of that gentleman through, my lord, inheritance, my lord? This is just contradictory because when they will go on the basis of inheritance, since their father predeceased the original owner, so they have no right. Inheritance, my lord, stop there. And my lord, under the Mohammedan law, the wife, brothers, and sisters, they will got the property of the deceased who having only wife and only son predeceased him. So this is another contradictory. Suit for declaration injunction restraining the defendant present opposite party before your lordships not to change the nature and character of the suit property or not to interfere with their possession. This much. My lord, kindly have a look. This is the, my lord, I have though not annexed, my lord, it is in a finding. It is a finding. My lord, kindly have a look. I am showing, my lord. I have marked it, my lord. My lord, kindly have a look. My lord, Nirupam deed, it tells about, my lord, in page, running page, my lord, 1, 2, 3, 4, running page 4. It is also admitted fact that on 27 March 1963, Sheikh Muhammad Rustam Ali, our predecessor in interest, executed a Nirupam deed in respect of suit plot as well as non-suit plot. It is 5th page from the judgment of the appellate court. Yes, court's finding last of all that they are the co-owners. How can it be, my lord? If the defendant present opposite party in trials court, they are claiming the property, they got the property sometime in 1996 when they are relying on deed executed in their favor in 2004. 2004 to 2013, during the lifetime of the original owner, no claim, no change of record of rights, no claim, even by Ishaq Ali. If the Ishaq Ali, original owner, he has no, my lord, prohibition to execute the any deed in favor of anybody during his lifetime. But if he done so, why he should not claim? Why the record of rights will not? My lord, of the defendants saying, oh, yes, my lord, kindly see written statement, then I have annexed my written statement. Yes. My lord, disputing all the plain case, they stated, what is positive? No? Yes. They dealt both. They relied upon. Yes. Well, it is Bengali page 7 written statement, page 43, inner page 7 of the written statement, 28 paragraph 28. Paragraph 28. In 27 বিবাদীগণ অত্র বর্ণনাপত্রে স্পষ্টত স্বীকার করিল না তাহা এই বিবাদীগণের স্বীকারোক্তি বলিয়া গণ্য হইবে না, which was not, my lord, dealt with. তাহা বাদে now from 28 প্রকৃত বিবরণ এই যে নালিশি খ তপশিল বর্ণিত ভূমি সহ অন্যান্য বেনালিশি দাগের ভূমি বাদী বিবাদীগণের পূর্বাধিকারী রুস্তম আলী সত্ত্ব দখলী ভূমি ছিল, অ্যাডমিটেড। রুস্তম আলী নালিশি খ তপশিল বর্ণিত ভূমি সহ অন্যান্য বেনালিশি দাগের ভূমিতে সত্ত্ববান দখলকার থাকা অবস্থায় 27 মার্চ 1963 তারিখে সম্পাদিত রেজিস্ট্রিকৃত সাচ নিরূপণ দলিল দ্বারা নালিশি ও বেনালিশি দাগের ভূমি তাহার পত্নী নেজমান বিবি ও পুত্রগণ শেখ আরফান আলী, শেখ মোহাম্মদ ইসাক ও আলী মোহাম্মদ কন্যা লুপ্তেন্সন নিরূপণ করিয়া গ্রহীতাদের অনুকূলে নিরূপণকৃত ভূমির সত্ত্ব দখল পরিত্যাগ করিয়াছিল। ইয়েস, নালিশি জগন্নাথপুর মৌজায় বেনালিশি 88 দাগের 1 ডেসিমেল ভূমি সহ নালিশি 292 দাগের 5 ডেসিমেল ভূমি গত ইংরেজি 11/12/86 1389 24 অঘ্রাণ তারিখে সম্পাদিত রেজিস্ট্রিকৃত সাচ নাম্বার কোবলা দ্বারা বিবাদীগণের পূর্বাধিকারী শেখ মোহাম্মদ ইসাক আলীকে বিক্রয় করিয়ে তাহার অনুকূলে বিকৃত ভূমির সত্ত্ব দখল পরিত্যাগ করিয়েছিল। সাম মাইনর লিগাল এয়ার্স of the enjoyment of নিরূপণ পত্র they transferred in favor of ইসাক আলী admitted। মৃত শেখ মোহাম্মদ আরফান আলী ওয়ারিশগণের মধ্যে তার 2 কন্যা মানুয়ারা খাতুন ও মঞ্জিলা খাতুন ঝুমুর পিতৃত্যক্ত নালিশি ও বেনালিশি দাগের ভূমিতে সত্যবতী ও দখলকারী থাকা অবস্থায় they also transferred জগন্নাথপুর মৌজা বেনালিশি 88 দাগের 2.5 ডেসিমেলস ভূমি সহ নালিশি 292 দাগে 17.5 ডেসিমেল ভূমি ইংরেজি 13/12/1986 ও 26 অঘ্রাণ তারিখে সম্পাদিত রেজিস্ট্রিকৃত 8434 1986 দ্বারা কোবলা দ্বারা বিবাদীগণের পূর্বাধিকারী শেখ মোহাম্মদ ইসাক আলীকে বিক্রয় করে। এত ব্যতীত বিবাদীগণের পূর্বাধিকারী শেখ মোহাম্মদ ইসাক আলী পূর্বোক্ত কোবলা সমূহ মূলে অপরাপর কোবলা ও হস্তান্তর দলিল মূলে পিতা শেখ রুস্তমের সম্পাদিত নিরূপণ দলিল মূলে নালিশি ও বেনালিশি দাগের ভূমিতে সত্যবান দখলকার ছিল। পূর্বোক্ত মতে সেই মোহাম্মদ ইসাক আলী ও শেখ ইসাহাক আলী অত্র মোকদ্দমায় অন্তর্গত নালিশি দাগের ভূমি ও অন্যান্য বেনালিশি দাগের ভূমিতে সত্যবান ও দখলকার থাকা অবস্থায় ভূমি WBLR অ্যাক্টের বিধান মতে রেকর্ড করিয়া খতিয়ানে লিপি প্রচারিত হইয়াছিল। এই বিবাদীগণের পূর্বাধিকারী শেখ ইসাক আলী তাহার অর্জিত ও তাহার নামে এলআর সেটেলমেন্ট রেকর্ডে লিখিত ভূমি সমূহের মধ্যে নালিশি সাবেক 298 দাগে 40 ডেসিমেল, 227 দাগে 7 ডেসিমেল, 228 দাগে 5 ডেসিমেল, 229 দাগে 7 ডেসিমেল, 425 দাগে 53 ডেসিমেল, 426 দাগে 17 ডেসিমেল, 232 দাগে 12 ডেসিমেল, 233 দাগে 3 ডেসিমেল, 289 দাগে 5 ডেসিমেল, 220 দাগে 9 ডেসিমেল, 292 দাগে 46 ডেসিমেল, 231 দাগে 10 ডেসিমেল, 234 দাগে 3 ডেসিমেল, 221 দাগে 26 ডেসিমেল, এগ্রিগেটলি 2 একর 43 ডেসিমেল ভূমি তার পৌত্রগণ শেখ জিন্নাত হোসেন ও শেখ মোহাম্মদ ওয়াসিন হুসেন তথা বিবাদীগণকে ইংরেজি দিস ইজ দ্য ডিড অফ গিফট কন্টেনশন অফ ডিড অফ গিফট দিস আর দ্য প্রপার্টি সোল্ড under alleged deed of gift in favor of the grandson 23rd December 1996 and in suit they claim it is 2004. No mutation till 2022 or during the lifetime of Ishaq Ali. No mutation. So what prompted the donor to mutate the property in favor of his granddaughter? Even after his death 13 to 22, no problem. We were peacefully enjoying the property, which we obtained through Nirupon deed, some executed in 1963, undisputed. So, my lord, now if the defendant have any better right or better title or better instrument, they should come forward first with that instrument. But in trial court, they are relying on the 2004 deed. They are saying 1996 they obtained. In my lord appellate court, they are claiming through my lord inheritance, my lord. So, my lord, if arguing on behalf of the plaintiff, I should accept this, that if they claim on the basis of the inheritance, who are claiming the son of predecessor son, then it has to be presumed unsafely that they had no document or the alleged deed of gift is no document or manufactured for the purpose of depriving this plaintiff. But in one hand, they can't claim in two ways, and if they come, when they come through inheritance, so they will be precluded from claiming because their father predeceased the original owner. But this is the this is my lord in the trial appellate court's judgment. it is discussed that they, my lord, yes, I am coming. My lord, your lordship kindly come, third, from fourth page, my lord, kindly come. Fourth page, my lord, kindly come. Says by and by virtue of the said. But I am reading from the fifth line from the top. By virtue of the said gift deed, total 2 acres 43 decimals of land from different plots of shoot land was transferred in favor of the grandson of Sheikh Muhammad Jinnat Hussain and Sheikh Muhammad Wasim Iqbal Hussain alias Sheikh Wasim Iqbal Hussain, that is defendant number 1 and 2. It is stated that defendant number 1, 2 are minor when the said gift deed dated 23rd December 1996 was executed, and on behalf of the minors, their mother Manwara Begum had taken the possession of their share in the shoot plot. It is stated that after attaining majority, defendant number 1, 2 have taken possession and they are now possessing their share in the shoot property. It is stated that Muhammad Ishaq Ali during the lifetime Yes. No, my lord, it is also stated by dint of this inheritance they are claiming. Yes, that I am coming. Recorded their names below, or they have executed deed of gift in favor of the sisters of transfer. My lord, kindly see next page. Next page, my lord. Third line. After the death of Muhammad Ishaq Ali, his wife Fuljan Bibi, daughter Sabina Yasmin Bibi, Imtera Bibi, Nargis Pavin Bibi, Nursetra Bibi, and 2 grandsons, namely Muhammad Jinnat Hussain and Wasim Iqbal Hussain, son of Petitioner's son, Muhammad, acquired his property as legal heirs according to Muslim law. Well, how can it be, my lord? If so, they are not claiming, they disown the deed of gift, existence of any deed of gift, though in both the trial court and as well as the appellate court, there was no production of the deed of alleged deed of gift. But if there is any deed of gift, how they can claim through inheritance? This point struck me that there is something, my lord, fishy. It belies their claim of the existence of deed of gift by their grandfather. And my lord, my claim is only confined to, my lord, kindly have come to plain itself, my lord, page 34. Page 34. My lord, more 63 decimals, 63.649. This is co-scheduled property we are claiming. It is our exclusive position, exclusive right through Nirupon and on some portion on the death of that gentleman who Ishaq Ali. And my lord, this co and co 1 includes co. Co topsil includes, my lord, 360 decimals. So we have no problem. We are not claiming. Out of 360, only 63.649. They also tried to grab this property, and they tried to, my lord, digging the said land in order to make pisciculture, starting pisciculture. In that event, in pending shoot, no permission, since there is the appellate court set aside the order, taking advantage of that, they are trying to, for that yesterday I mentioned, my lord, my client phoned me, they are trying to digging out in order to frustrate my right. This is, my lord, my urgency, and this is my prayer. I am, my lord, honestly, my lord, prayed in Kothi Tapusil 63.649. The appellate court also said there are some co-owners. Well, if any co-owner, admittedly, there are some co-owners, but those who not disturbed by position, who are not made party in the suit, how that landed, my lord, appellate court take that plea that there are other co-owners, but definitely not the defendant. We say there are other co-owners who are agreed with me. Page 8. Appellate court order, my lord. I'm coming. My lord. Yes, plaintiff in their pleadings did not admit. No, my lord, it is put on our mouth. It is content. My lord, when my lord, we are disputing from the trial court, my lord, with the document, my lord, wrong. Yes, yes. Your lord, it is correct, my lord. But my lord, my lord, yes. Just, yes. Yes, admitted the plaintiff are not the exclusive. My lord, we are the, it is our case. Yes. My lord, if from the judgment itself, the finding is contradictory, finding is there, then my lord, which one would prevail, my lord? My lord, I submitted candidly that not only plaintiff, there are some other heirs, excluding the defendant, are the co-owners in respect of co-scheduled property. It is my case. And appellate court says, since there are some other co-owners, but definitely not the defendant, who are offering resistance to me, which prompted me to file suit in 2022. It is not that just on the death of Ishaq Ali, I came for our client came forward before the trial court to get undue advantage. 2013 October, Ishaq Ali died, and my lord, 22 in the year 2022 we filed the suit for injunction, and my lord, what, my lord? My lord, now, yes. My lord. Well, my lord, now we are before the High Court. But when my lord, accepting those unwilling comments, or unwilling on our part, it is unintentional, unadmitted. My lord, but accepting that portion, my lord, vital thing is that this claim of property through inheritance, on the basis their claim, it hits their claim. One time in one mouth over the self-same property, one time by deed of gift, and one time by inheritance. It is self-contradictory, my lord. It is a point of law. And now we are before your lordships. Whatever your lordship will think fit and proper, but my lord, I prayed for. My lord, then kind of fix, my lord. Stay is for limited period is required. Otherwise, my lord, it will be infructuous. My lord, they started digging. Limited period. For limited period, my lord, for up to Thursday.
Thursday, I will not be here. Next week.
Well, I have no problem. Limited, my lord. Otherwise, my lord, my client will suffer, my lord. During the pendency of the appeal, But no, 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 no. Only dismissal. No, 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 no. In their favor, there is no order. Our order was turned down. My lord, till 38, my lord, limited, my lord, not to change nature and character. This much.
They may be kept on 17th April.
আরে কোথায় গেলেন? এটা রাখুন। কোথায় হবে?
Senior is not.
May I mention a very small item number 4 of today. Your lordship has been released.
ভালো করে বাদু কোটাকে সত্যি না যায় যেন।
I'll intimate the others. I won't be available on 30th.
Those then may be kept on the 16th. The Passover matters. Along with my lords. Yes, ma'am. My lords, along with the monthly list item number 755. 108, 108, 110.
I'm sorry. Yes.
The reply is good.
और उसको बोलो मेरा just ask my chat to come. मेरे को judgments guarantee दिखाओ. Lord, देखिए हम लोग की कोशिश मतलब मैं जाने ना कि जानिश तो मामला शुरू होता है. I'm sorry, my lord. Too many, my lord, devices, but I would much prefer, my lord, my good paper brief, my lord, which either is here or not here. Now, my lord, Mr. Shah's, my lord, argument has been, my lord, if I understand, my lord, correctly, he, my lord, submits that first, my lord, the bank guarantee is conditional. And my lord, first, my lord, his submission, my lord, really, my lord, take, my lord, to go to, my lord, the crux of, my lord, what he, my lord, wants to, my lord, submit. My lord, first, my lord, saying, my lord, that bank guarantee is really a conditional bank guarantee. It's dependent on the contract. Therefore, you cannot invoke it. Second, my lord, he says that today, the purchase order which was placed, that did not result into a contract. Therefore, no supply was to be made by me or made. And therefore, my lord, no question of, my lord, payment under that contract. They are really, my lord, interlinked in that sense. Because, my lord, if it's an unconditional bank guarantee, then, my lord, there's no question of, my lord, linking it, my lord, with the contractual terms at all. He relies on certain judgments. I'll deal with it. And one of his, my lord, main judgments, my lord, is Gangotri. My lord, will find, my lord, that's, my lord, yes, my lord, that's 2016-11 Supreme Court cases 720, where, my lord, it is said, and since my lord has taken, my lord, let's, my lord, just straight away come to this judgment. He relies on, my lord, paragraph 40. Uh, 35, my lord, kindly come to 35. I, my lord, the question which fell
for consideration before this court in Ramanaran Foundry's case were first, what is the true interpretation of clause 18? Secondly, what is the meaning of word sum due and may become due under the contract or any other contract with the purchaser occurring in clause 18? Third, whether clause 18 impart the Union Amendment to make recovery of amount claimed by it by way of damages, liquidated or unliquidated, for breach of contract pending arbitration proceedings from the contractor. And lastly, whether in such case contractor is entitled to claim injunction against the Union of India from making recovery of such sum. Then Malad, kindly look at 36. Justice Bhagawati speaking for the bench in Ramanaran Foundry case examined the issue in greater detail in the light of law laid down English and Indian courts. Learned judge in his distinctive style, writing after examining the entire case on the subject, held that the expression sum due occur in clause 18 would mean a sum for which there is an existing obligation to pay in present, or in other words, which in present payable and due, and therefore recovery of only such sums can be made the subject matter of clause 18, which is presently payable and due. It was held that a claim which is neither due nor payable cannot be made the subject matter of clause 18. It was clause 18 does not create a lien on other sums or purchaser sums or damages. And then Malad also relied on, I think it's not relied, then Malad paragraph 40 is where at page 731 on perusal of the record of the case, that firstly arbitration proceeding in relation to the contract dated 22nd 8 2005 was still pending. Secondly, some claim by the respondents from the appellant does not relate to the contracts for which the bank guarantee had been furnished, but relates to another contract dated 22nd August for which no bank guarantee had been furnished. Thirdly, the sum claimed by the respondents from the appellant is in the nature of damages which is not yet adjudicated upon in arbitration proceedings. Fourthly, the sum claimed is neither a sum due in present time nor a sum payable. In other words, sum claimed is neither an admitted sum nor a sum which stood adjudicated by any court of law in a judicial proceeding, but a disputed sum. Lastly, the bank guarantee in question which is the nature of performance. This is very important. Being in the nature of performance guarantee, furnished for execution work of contract dated 14 July, and the work having been completed satisfaction of the respondent, they have no right to encash the bank guarantee. Similar on the facts of this case, then kindly look at clause 18, which is there. Which is at paragraph 31 at page 728, clause 18 is set out, because this is all a discussion on clause 18. Recovery of sums due. Whenever any claim for the payment of a sum of money arises out of or under the contract against the contractor, purchaser shall be entitled to recover such sum by appropriating in whole or in part the security, if any, deposited by the contractor, and for that purpose shall be entitled to sell on a realized securities forming the whole or part of any such security deposit. In the event of the security being insufficient at the balance, and if no security has been taken from the contractor, entire sum recoverable shall be recovered by appropriating any sum then due, or which at any time thereafter may become due to the contractor under the contract or any other contract with the purchaser or the government or any person contracting through the secretary. If such sum, even if not sufficient to cover the full amount recoverable, contract shall on demand pay to the purchaser, balance remaining due. So this is the clause which was factually being discussed in Ramanaran Foundry, on the basis of which Gangotri, and just relying on Ramanaran Foundry, Gangotri decided that if the sum is not adjudicated or ascertained, then the performance bank guarantee cannot be encashed. This was Gangotri. Now is aware that Ramanaran Foundry was in fact overruled by a 3 judges bench, and this Gangotri was also considered and was held to be per incurium, because this is the judgment I find also relied upon in the impugned order. Much is not here. State of Gujarat versus State of Gujarat versus what reference is it? State of Gujarat 2020, two Supreme Court cases my lord, page 540. My lord, kindly look at paragraph 19. Please, Sukhmani, page 547. Learned counsel appearing for the respondents has placed reliance on a judgment of this court in Gangotri Enterprises Limited versus Union of India to submit that till the deed of the government, demand of the government is crystallized or adjudicated upon, the government cannot withhold the money of the contractor. Since this case has been specifically relied upon, we are duty bound to go into the correctness of the view laid down in Gangotri Enterprises. The judgment in Gangotri Enterprises is primarily based on the judgment of a two-judge bench of this court in Union of India versus Ramanarayan Foundry. In this case, the court held that the government had no right to appropriate the amounts claimed without getting it first adjudicated. Relevant portions of the judgment reads as follows. Then Ramanarayan Foundry, then is considered. At paragraph 6, then kindly turn over and see. I'm not reading it, because that was Ramanarayan Foundry. Yes, 20. The judgment in Ramanarayan Foundry was specifically overruled on the issue in hand by a three-judge bench of this court in H.M. Kamaluddin Ansari versus and Company versus Union of India. In this case, there was a general condition which entitled the government to recover the damages claimed by appropriating any sum which may become due to the contractor under other pending bills. In this case, this court disagreed with the findings in Ramanarayan Foundry and held as follows. Then H.M. Kamaluddin is quoted. With profound respect, we find that the aforesaid observation is incongruous with the proposition law laid down by this court. Just before this observation, we find it difficult to agree with the observation of the court that the impugned order in form and substance being the negative, respondent could refuse to pay such if it thinks it is a valid defense, and if it chooses to do so, there would be no breach of the injunction order. Then true that the order of injunction case was in negative form, but if an order injuncted a party from withholding amounts due others and pending bills, other order necessarily means the amount must be paid. Then that is quoted. Then if again 549, paragraph 21. In our opinion, the judgment rendered in Gangotri Enterprises Limited is per incurium, because it relies upon Ramanarayan Foundry, which has been specifically overruled by the three-judge bench in H.M. Kamaluddin Ansari. Gangotri, with great respect, first of all, factually it's a different case altogether, because I'll show our bank guarantee which is there. And in any event, the principle which was provided by Gangotri was said to be per incurium because Ramanarayan Foundry was overruled. And this is the judgment which they also relied upon in the first court. If looks at the impugned order, they have relied upon Gangotri and Kailashnath. Now, Gangotri overruled, and or rather per incurium, and Kailashnath is on a completely different principle. That is nothing to do with invocation of bank guarantee. And correct. So what my learned friend says, Kailashnath is correct. But if I fail to show that I have suffered any damages, then he'll get back his money. He'll get back his money. Now, what is the case which he runs? There were total guarantee given of 8 guarantees of 8 crores. And from time to time, he placed purchase orders according to which it was supplied. The 8 crores bank guarantee was constant. So whatever came, we were paying, they were paying, we were supplying, they were paying. Now at some point of time, in I think August, what was the 29th? 26th August. 26th August. The last purchase order which they, according to us, they placed, and we had to in turn place it someone else to get the material. So in terms of that purchase order, they did not accept. They said, no, sorry, we have not accepted, or we have not really accepted your contract. And on that basis, they were not willing to honor this last contract which was between, which we say there's a contract between parties. He said there's no contract. At that time, there were already outstanding amount, admitted outstanding amount, which he admits, of 4 crores. So when we invoked all the 8 bank guarantees, they stopped us. Before the division bench, in section 9, they stopped us. We came before the division bench. Before the division bench, they said we only admit 4 crores to be paid. So the 4 crores was then admitted on the basis of admission. They say that we are money is outstanding. So they paid. And the other 4 crores, which we had invoked, was sent, was made the subject matter because their section 9 had not been decided. So that section 9 became a section 17 before the arbitration. And we quite naturally, we also went up to the Honorable Supreme Court being agreed. Supreme Court said you have your section 17 remedy. Now this is the situation. It's his version against my version with regard to what is the contractual dispute. Quite naturally, he will say there is no contract. So that he doesn't suffer a claim of damages from me. And I say he's breached the purchase order by placing the purchase order, by not then following it up to ensure that goods are supplied and accepted by him. Now the bank guarantee is devoid, cannot look into all this disputes at all. That is what I want to show. So when he says it's a conditional bank guarantee, with great respect, we disagree. And in fact, that is not his case also in the petition. Conditional bank guarantee. Subject to correction, I have looked at it. I don't know, but it is not his case. Check again. I checked. I can find in the petition that it is a conditional bank guarantee. Now he raises a dispute saying there is no contract. Very well, that is what the arbitrator will have to decide. So that is the subject matter of the arbitration. And just 2 separate points he takes, with great respect, which I don't think are. He says, oh, you went up to the Supreme Court, but even the Supreme Court did not give you payment. That is neither here nor there. Supreme Court did not refuse me payment. Supreme Court said that you have your section 17 which has to be decided. Then he also says that you are not aggrieved because the arbitrator actually says take the money and keep it. He doesn't let you use it. So he is in a sense better off because his money then stands secured. Yes, of course I could have preferred an appeal. Not having preferred an appeal, not going against a section 17 order, is not a point in his favor. If they had asked me, I would have said yes, prefer an appeal from that also. Quite naturally, because the money should have straight away come to me. Arbitrator shouldn't have done it halfway house. Arbitrator perhaps felt that he should be more equitable than he was required. That's why he said, no, you let the bank guarantee be invoked, the money will be kept with you. So those 2 points are not defense against the main issue as to whether the bank guarantee is unconditional or not first, and secondly, whether I can invoke it for damages. If these 2 things are there in the bank guarantee itself, there is no question today. He can enjoy an order. He can enjoy an order which will be against law. That's my respectful submission. Now, kindly just look at the bank guarantee. Once more, I'm sorry, because that is the crux of really the matter. The ones which are subject matter, they are similarly worded. I think page 147. Is it 147? 147.
It is clear in the convenience compilation filed by them.
Of the convenience, I don't know. I'm told it's very clear in the convenience compilation.
Inconvenience compilation.
Convenience compilation. Devin, please. No, I don't have it. You have a copy? Very well. What page is it?
It's page number 48 of their convenience compilation.
Well, they have given a convenience compilation. Where any bank guarantee, just take the wordings of the bank guarantee. Which one is this? IndusInd Bank. Page 48. 48?
48 of their convenience compilation.
48 of their convenience compilation. I'm told it's a clear copy. Right? It should be, it should say BG number, last four numbers 1862 and issuance date June 20th, 2024. Now, let's see bank guarantee 2 OFB Tech Private Limited. Then BG expiry, BG claim expiry date. All that there. Then, ladies and gentlemen, then line 11. At the request of Rian Watertech Private Limited having its registered office at such and such, we IndusInd Bank Limited, a banking company incorporated registered under such. Then the address is given. Hereinafter referred to as the beneficiary OFB. Under the terms of the agreement, hereinafter referred to as the purchase agreement, to supply and or facilitate credit for supply, and or facilitate credit for supply of material services from OFB or its group of companies or its network of suppliers as per agreed credit terms of the purchase agreement. Then next line 25 is extremely important. We hereby irrevocably agree and undertake to immediately on your first written demand credit the full amounts demanded from us to your account number such and such, then address or any other account as specified in your demand, full stop. Then such payment under any credit facility availed by the customer will be made by us to you absolutely, unconditionally and irrevocably under the purchase agreement without any contestation, protest or delay on our part, and without any demur, set off, counterclaim, deductions or withholding charges or taxes of any kind now or hereinafter imposed, levied, collected, withheld or addressed by any government and any authority whatsoever. Then in the event of tax deducting being mandatory order, amounts being paid as shall be gross entry sunsets. Then next line 39. We further agree, and this is most important, we further agree that the beneficiary shall be sole judge whether customer has committed any breach or breached any of the terms and conditions of the agreement, and and the extent of loss, damage, cost, charges and expenses suffered due to any default stroke delay on the part of customer in payment of beneficiary's dues, charges, costs, expenses or payment demanded by the beneficiary in said agreement. To give effect to this guarantee as per the provisions of Indian Contract Act as amended from time to time, banks shall be considered principal debtor. Then we further agree and undertake to pay to the beneficiary any money so demanded, irrespective of any dispute or disputes raised by the customer. We further agree that the beneficiary shall have the fullest liberty, without its consent and without affecting any manner its obligation hereunder to vary any of the terms and conditions, bank shall be released from the sunset. Then not to be. So line 25 to line 47. In my most humble submission, gives complete, and that is what irrevocable unconditional guarantees are. It may sometimes be injustice on him, it may sometimes be injustice on me also. But the law is that if there is a guarantee which is unconditional and irrevocable, then the payment has to come. Payment has to come. Then if I am wrong, you will get your money with interest. as my lord has seen several government contracts, my lord, several authorities, my lord, whenever my lord there's a dispute, the first thing they do, my lord, is to invoke the bank guarantees. And that, my lord, doesn't amount. He, my lord, says, oh, this is special equity. No, that is in every case. That is in every case. Special equity is not that, my lord, the invoking authority may be wrong. That is not special equity. Now, my lord, sees clause 18, Ramanarayan Foundry, they said unless there is an adjudication, no claim can be made. And that is exactly, my lord, what a bank guarantee avoids. Bank guarantee avoids, my lord, waiting till any adjudication is made. Then otherwise, my lord, with great respect, my lord, there's no point in, my lord, giving any bank guarantee. Because in every bank guarantee, there will be a dispute. Person, my lord, who's opened the bank guarantee and person who has to claim, there will always be a dispute. My lord, this court, my lord, the court which is adjudicating the bank guarantee is not going to go into it. Today is not going to go into it. My lord, I have got today, my lord, an order, my lord, in section 70, which says, yes, go ahead with, we are satisfied, go ahead with the invocation of the bank guarantee. And what my learned friend tries to do, which is with great respect, my lord, wrong, he can't, my lord, link it with, my lord, one purchase order, this purchase, that purchase order. There were several purchase orders, and all these bank guarantees, my lord, are all, my lord, similarly worded. There were transactions between the parties as well as a general security. All this, my lord, 8 crores, my lord, was given and remained as, my lord, a revolving in that sense of credit.
This particular bank guarantee, my lord, related to this disputed purchase order is differently worded.
No, they're all same.
No, my lord. If your lordship sees, my lord, the contract, my lord, makes a different provision for bank guarantee here.
No, my lord, this bank guarantee doesn't say, my lord, anything. It doesn't refer to, my lord, this purchase order. It cannot, because according to him, there's no purchase order or there's no agreement.
The invocation, my lord, I'm sorry, my lord, but the invocation was made, my lord, even before this dispute had arisen. Before the dispute regarding this purchase order, before the debiting of the account regarding this purchase order, the invocation had been made much prior thereto. Now, my lord, they are saying, my lord, this is, my lord, the...
My lord, I'm just only showing the language of the bank guarantee to show it is within my jurisdiction to make a claim. Of course, you will dispute it. Of course, you will deny it. The bank guarantee words it that in that manner, saying it is for me to decide. And I will show, my lord, all his other cases, my lord, and 2 of them, my lord, including the Supreme Court, my lord, there, I will just show that, my lord. How, my lord, they are not, my lord, absolutely, my lord, doesn't lie, my lord, so far as this is concerned. I am on the kindly, my lord, look at the words of the bank guarantee, in view of the words of the bank guarantee, whether the first court could have overtaken the order of the learned arbitrator to say, I'm injuncting you from taking this money. That is, my lord, really the question. Now, my lord, kindly look at, Lord, I'll come back. Yes. It will depend on, my lord, whether the contracts, my lord, whether the bank guarantee says, my lord, it is in respect of contract X. Unless, my lord, the bank guarantee specifically says this is in respect of contract X and only claims in respect of contract X will come. Because it is really, my lord, the beneficiary's prerogative. Correct. It's a claim. I've said I've suffered damages, and I have. I shall prove it, my lord, in the arbitration. You placed purchase order on me, you did not pursue it. I have, my lord, all the WhatsApp messages saying that he's accepted. You did not pursue it. You ensure, because I had to, my lord, place an order on someone else to get the goods. So I have suffered damages, and I shall place this all, my lord, before the learned arbitrator when the time comes. So today, my lord, we are only on the section 17. Am I within my right to invoke a unconditional bank guarantee? This is really the question. My lord, didn't we show those records? My lord, sorry, my lord, I had shown those. Absolutely not, my lord. The standard, my lord, is extremely narrow. Delhi High Court, didn't we show? I'm sorry, my lord, since my lord, I had argued it before. I thought, no, my lord, it is, my lord, my lord, the law is that, my lord, that Delhi High Court as well as, my lord, our courts, my lord, which we have shown, from a section 17, section 37 is supposed to be extremely narrow. The logic being, from the final order also, you are restricted to only the ground in section 34. No, even narrower. Because there's an interim order, there's more discretion. From a final order, my lord, you are restricted, my lord, by section 34. Only on the grounds of section 34. Doesn't mean, my lord, an interim order by an arbitrator will then become a regular appeal. Section 37 scope, my lord, is narrower. I mean, judgment.
So we have given those.
My lord, I think, my lord, perhaps, my lord, these are for no, where are those? Justice Bhattacharya and all those judgments here, Delhi High Court and all that.
So it is annexed along with the petition as well.
Yes, my lord, I thought, my lord, I had given those judgments. My lord, saying, my lord, the scope is extremely narrow, and that's, my lord, my first grievance. Saying that ex parte you have stated. The order was, my lord, state ex parte. It is not a regular appeal where you can just stay the order without hearing the other side in a section 37 appeal. It's not a regular appeal. Now, my lord, kindly look at, my lord, his judgments, my lord, which he relies on. And then, my lord, I'll just show, my lord, that invocation and kindly see now. So, Gangotri, my lord, I've dealt with. My lord, kindly see first, my lord, National Agricultural Cooperative. I think, my lord, paragraph, yes. My lord, I'm not sure. I think, my lord, this was relied upon only to show, my lord, interpretation of, my lord, a contract. Paragraph 9, rules of interpretation require the clause to be read in the ordinary and natural sense, except where that would lead to an absurdity. No part of a term of clause should be considered meaningless surplus when it is in consonant with other parts of the clause and express the specific intention of the parties. When read normally, arbitration clause makes it clear that the matter in dispute shall be referred to when finally resolved. And, my lord, I am relying on this to say, my lord, that's exactly what, my lord, the bank guarantee doesn't say. It says it has to have a context of why, my lord, this bank guarantee is being issued. It has to have a context in why, my lord, the bank guarantee is being issued. The context is, my lord, that there are purchase agreement. My lord, kindly, my lord, just have another, I'm sorry, my lord, I'm in the bank guarantee, line 31.
Yes.
Absolutely unconditionally, irrevocably, under the purchase agreement. It is not, my lord, under X purchase agreement or Y purchase agreement.
It's not linked to one specific purchase agreement. It's purchase agreement.
All purchase agreements, my lord, provide for security by way of bank guarantee only for goods sold and delivered. Nothing else.
My lord, the purchase agreement may say anything. Purchase agreement may say anything. But purchase agreement, my lord, cannot override the terms of the bank guarantee, because bank guarantee, my lord, is a contract between, my lord, the bank and me. I'm sorry, my lord, my learned friend is putting, my lord, the cart before the horse. Your agreement might say anything, our agreement, but unless you can show that this is incorporated in the bank guarantee itself, because the bank actually doesn't see you. Bank is under an obligation to make payment to me under an irrevocable unconditional bank guarantee. Yes, of course, in Mr. Shah showed, my lord, it says irrevocably under the purchase agreement dated such and such, if there is a loss suffered under the said purchase agreement, or if there's something under the purchase agreement, or, my lord, some other clauses, my lord, which are put in as restriction. But here there is none. Purchase agreements, my lord, contemplate bank guarantees would be given. And these are not, my lord, new bank guarantees. These are all, my lord, subsisting from before. So from time to time, my lord, he placed purchase orders. I, my lord, supplied. Like I said, my lord, I supplied. Otherwise, my lord, where is the question, with great respect, my lord, the previous 4 crores coming up? I invoked all 8 crores. You came and said, only, no, this 4 crores you take. Now, my lord, so, my lord, his judgment in 2007, 5 Supreme Court cases 692. My lord, my submission is, my lord, this doesn't apply, my lord, because the terms of the bank guarantee doesn't say so. Just because it says it is issued under the purchase agreement doesn't mean, my lord, the terms of the purchase agreement, my lord, are included, my lord, in the bank guarantee. Then, my lord, 1969, Supreme Court cases 611. And you see, my lord, this was in context, my lord, of a compromise decree, my lord, in a leave and license. Again, my lord, I do not understand, my lord, how, my lord, we can make this applicable. What, my lord, what fell from, my lord, obviously that's the reason, but I don't see, my lord, this is what, my lord, it says. Paragraph, my lord, 7 at placitum B, no term in a contract should be considered superfluous if it can be given some reasonable meaning. So, my lord, these are all interpretations of a contract. Here, my lord, kindly look at the bank guarantee. My lord, today if the court thinks that no, actually this is it's a conditional and restricted, my lord, by the terms of the purchase order, my lord, then quite naturally, my lord, I'm not. That's not, my lord, what the arbitrator has also held. That's not what the arbitrator has held. When we look at the trial court order, there has to be a reason why you have stated that. You rely on Gangotri, and that was his case. First, his case was, my lord, that damages cannot be, it's an unascertain sum of money. You cannot use your claim for damages to invoke my bank guarantee. Now it seems he's given up that case. He's saying this is a conditional bank guarantee. So this is, my lord, again, my lord, on the question of, my lord, interpretation. My lord, there's no question of any superfluous word. It doesn't, my lord, say, it doesn't incorporate, my lord, the terms of the purchase agreement into, my lord, the terms of the bank guarantee. Then, my lord, kindly look at, my lord, the Hindustan construction was cited. Now, my lord, kindly look at Hindustan construction. 99 8 Supreme Court cases 436, and all these judgments, my lord, I know, my lord, is absolutely familiar with. My lord will remember, my lord, what had happened here. My lord, the bank guarantee was, my lord, given to, my lord, the chief engineer. And, my lord, the executive engineer, my lord, had invoked. My lord recalls this matter because this is, my lord, one of those rare cases when one could come up and say, please give me an injunction in respect of a bank guarantee. So kindly, my lord, look at paragraph, my lord, first 2. Bank guarantee is given, for mobilization advance and performance bank guarantee. Then kindly come to straight away paragraph 8. And kindly see, this is now a bank guarantee is the common mode of securing payment of money in commercial dealings, as the beneficiary under guarantee is entitled to realize the whole of the amount under the guarantee in terms thereof. So all this in my favor. This is the law. Terms thereof, irrespective of any pending dispute between the parties on whose behalf the guarantee was given and the beneficiary. Then in contracts awarded to private individuals or the government, which involve huge expenditure, as for example, construction contracts, bank guarantee usually required to be furnished in favor of the government to secure payments made to the contract advance from time to time. Then the last 5 lines from Placidum G. It is for this reason courts are reluctant to granting an injunction against the invocation bank guarantee except in the case of fraud, which should be established fraud, or where irreparable injury was likely to be caused to the guarantor. Then laid down in various code. Then kindly come to paragraph 9. What is important thereof is that the bank guarantee, these are all in my favor, should be in unequivocal terms, unconditional, and recite that the amount would be paid exactly what it says without demur or objection, and irrespective of any dispute that might have cropped up or might have been pending between the beneficiary under the bank guarantee or the person on whose behalf the guarantee was furnished. The terms of the bank guarantee are therefore extremely material. Since the bank guarantee expresses an independent contract between the bank and beneficiary, both the parties would be bound by the terms thereof. The invocation thereof will have to be in accordance with the terms of the bank guarantee, or else the invocation itself would be bad. Now, I'm kindly see why they refused it here. At paragraph 13. Sorry, it starts at paragraph 12. It was other way around, I think. If engineering. Paragraph 12, it was in terms of the above clause that the bank guarantee was furnished by HCCL. It provided as under the executive engineer, Kharkai Dam Division 2, Icha, Post such and such, District Singhbhum. And then kindly come to paragraph 13 at page 444. The bank in the above guarantee no doubt has used the expression agree unconditionally, irrevocably to guarantee payment to the executive engineer on his first demand without any right of objection, but this expression immediately qualified by the following sunset clause. Then kindly come to paragraph 14. My learned friend wants to read paragraph 14. This condition clearly refers to the original contract between HCCL and the defendants, page 444. And the defendants and postulates that if the obligations expressed in the contract are not fulfilled by HCCL giving to the defendants the right to claim recovery of the whole or part of the advance mobilization loan, then the bank would pay the amount due under the guarantee to the executive engineer. By referring specifically to clause 9, bank had qualified its liability to pay the amount covered by the guarantee relating to advance mobilization loan to the executive engineer only if the obligation under the contract were not fulfilled by HCCL or HCCL has misappropriated any portion of the advance mobilization loan. It is in these circumstances that the aforesaid clause would operate and the whole of the amount covered by the mobilization advance would become payable on demand. The bank guarantee thus could be invoked only in the circumstances referred to in clause 9, whereunder the amount would become payable only if the obligations are not fulfilled or there is misappropriation. That being the so, bank guarantee could not said to be unconditional and unequivocal in terms, so the defendant could be said to have an unfettered right to invoke the guarantee and demand immediate payment thereof from the bank. This aspect of the matter is wholly ignored by the High Court unless an interference order injunction granted arbitration defendant restrained from the guarantee. With great respect, where is this clause in our bank guarantee? If paragraph 13 will find Kindly, my lord, look at paragraph 13 once, my lord. Kindly see, my lord, what is the clause? What is in quotation? It says unconditional, but these expressions are immediately qualified by following. In the event that the obligations expressed in the said clause of the above mentioned contract have not been fulfilled by the contractor, giving the right of claim to the employer for recovery of the whole or part of the advance mobilization loan from the contractor under the contract. With great respect.
The next line it says, this condition clearly refers to the original contract.
Yes, because it says so. Let's not read. I can also, let's not read things out of context. In the event that the obligations expressed in the said clause of the above mentioned contract have not been fulfilled by the contractor. Well, let us see, where is this clause in our purchase agreement and bank guarantee to say that if conditions are not fulfilled under any of the purchase agreements, then no invocation. I'm grateful. I'm relying on this. And then kindly look at paragraph 21. Sorry, paragraph 18 first. I'm so sorry. Paragraph 18, page 447. This guarantee has been furnished to the chief engineer, but was invoked by the executive engineer by a letter addressed to the branch manager of State Bank of India Commercial Bank rating as under. Then, kindly now look at paragraph 21. Kindly see, what is the ratio? As pointed out above, bank guarantee constitutes a separate, distinct and independent contract. This contract is between the bank and the defendants. It is independent of the main contract between HCCL and the defendants. Since the bank guarantee was furnished to the chief engineer and there is no definition of chief engineer in the bank guarantee, nor is it provided therein that chief engineer would also include executive engineer, the bank guarantee could be invoked by none except the chief engineer. The invocation thus was wholly wrong and the bank was under no obligation to pay the amount covered by the performance guarantee to the execution. This is the ratio or the decision. Now, kindly look at crest, which is 2002 Bombay civil reports on 1999 SCC online Bombay 794. Well, here what had happened, Millard will find at paragraph 8, this related to making films after scripts were handed over. Kindly paragraph 8, 9 and 10 itself shows how it's different. There is no doubt that the courts are slow in granting temporary injunction to restrain realization of unconditional bank guarantee, and the grounds upon which the temporary injunction could be granted are now well settled. In order to restrain the invocation of bank guarantee, there should be good prima facie case of established fraud and special equities in the form of preventing irretrievable injustice. It is only in exceptional cases that in case of fraud or in case of irretrievable injustice that court should interfere. In the backdrop of well-known two exceptions of established fraud and irretrievable injustice, the question arises in the present case where the case of interference in invocation of bank guarantee court is made out. Adverting to the facts of the present case, it could be seen that under the terms of the purchase order, plaintiff was required to supply 4 films to the second defendant for a consideration of rupees 67 lakhs to be paid by second defendant. 60% of the consideration was paid by the second defendant to the plaintiff on 11th December 98. Delivery was to be effected by the plaintiff within 30 days therefore. However, there is sufficient material to show prima facie that the script was not finalized by the second defendant, enabling the plaintiffs to maintain the time schedule of delivery. Script for the films was finalized by the second defendant in the month of June 1999, and there is no dispute that in the month of June itself, 3 films were supplied. 4th film was also supplied immediately thereafter in the month of July 1999. Not only that, the second defendant accepted, accepted the supply of films made by the plaintiffs without any demur or objection, but they recorded their satisfaction of the films supplied by the plaintiffs. Vide their communication dated July 6, 1999. Of course, in the said communication, certain suggestions were made for improving the films, but no objection whatsoever was raised about the alleged supply or quality of films made by the plaintiff. The second defendant, having been satisfied with the supply, made the remaining payment of 40% to the plaintiff. The purchase order stipulates 100% of the value of the goods to be paid after full satisfaction. When the second defendant has paid the full price to the plaintiff, upon receipt of films, it has to be prima facie presumed that the contract has been performed by the plaintiffs to the satisfaction of the second defendant, for which the performance guarantee was given. Then Larsen and Toubro Limited, Maharashtra is looked at, and then kindly come to paragraph 10. Sorry, before that, after the quotation, after the quotation, at page 170, just before 170, in the middle it says, and the SCC online web edition is page 9, at the top left hand side, will find page 9. The appellants wrote to the first defendant on 21/2/1994 that the plant was completed, and so all bank guarantees have served their contractual requirement. On a perusal of relevant clause in the contract executed by appellant first defendant and the communication of first defendant dated 10 June, fairly clear the stipulations or conditions mentioned as per clause 70.2, 70.3, and 70.4 have been successfully fulfilled. Plant was admittedly taken over first defendant, guarantee given. That's from the quotation. Now, kindly come to paragraph 10. The apex court thus observed that the contract having been successfully fulfilled, invocation of bank, can you see, contract having been successfully fulfilled, invocation of bank guarantee, if permitted, would cause irreparable injustice. Present case is also a case where guarantee was furnished by first defendant for performance of the contract, and the said contract has been performed completely to the satisfaction of the second defendant. The plaintiff has thus been able to show special equities in the form of presenting irretrievable injustice, prima facie if the second is permitted to invoke bank guarantee to delay cause irretrievable injury. So what had happened, my lord? Plaintiff was supposed to make films. First defendant issued bank guarantee. Second defendant was to supply the scripts. 60% payment was already made to the plaintiffs. Scripts were supplied. Plaintiffs made the films, gave it to the second defendant. Second defendant said, we are satisfied, so you can make some improvement. That's what noted in paragraph 9. Then they also paid 40% of the balance amount which was to be paid, which amounted to complete satisfaction and performance of the contract itself. Then they invoked. With great respect, how are we, how is this at all relevant here? I'm saying I have a claim against you, that's why I've invoked. I'm not said, I've given up my claim for damages. I'm aggrieved by the fact that on the last purchase order, you did not purchase from me. And when I invoked, money was also outstanding for all the other purchase orders also. You came to avoid the invocation of 8 guarantees. You quickly said that, okay, please take away 4 pros, because that's what we admit. You may admit. But you have to show a defense to your bank guarantees to say, how is it fraud or how is it special equities? Now, the last judgment, kindly look at my lord, the our High Court, my lord. Here, my lord, will find straight away, my lord, my lord, here, my lord, an injunction was granted, my lord, by our courts, but kindly come to এটা হলো তোমার KC Electricals Private Limited. Lord, kindly come to my lord, internal page 6 of the judgment. Sorry, my lord, I just want to show from paragraph page 5. Considering the matter, in the middle, my lord, will find considering the matters pertinent to invocation of bank guarantee, where immediate urgent reliefs are allowed, I allowed the petitioner moved ex parte. I'm also prima facie satisfied. Court has the jurisdiction to receive, enter, and try the instant petition. So, my lord, first of all, this is an ex parte matter. Then, my lord, in that page, in the last portion of it, last, my lord, line, last 3 lines, depending on the fact scenario of the instant case. My lord, has that? I'm just reading from the middle of the sentence. It will, my lord, make out.
Yes.
And in particular, that the goods were supplied by October 2017, when, kindly see, invocation is sought to be made in May 2021. And that too, after the petitioner has paid a sum of $38,785 against the demand made by the respondent number 1 by its letter dated 7th April 2021. And the liquidated damages, even if imposed, is fully secured. That's, my lord, at the ex parte stage, my lord, this is what the learned judge says. Then, my lord, kindly skip over, my lord, all the, my lord, in the middle, and then kindly see, my lord, there is also in the last, my lord, maybe 15 lines, there is also no assertion. My lord, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10th line, my lord, from the bottom. There is also no assertion. It's after the word injunction, my lord. Yes. There is also no assertion for damages even after 3 years from the side of the respondent number 1, which may persuade me to refuse the injunction. The respondent 1 at the present at the highest can realize liquidated damage in case of failure on the part of the petitioner, which is quantified under the contract. Such quantified amount is otherwise secured. The respondent 1 at the present has no other claim as damages apart from liquid damages, having not yet been asserted, and its claim under the letter dated 7th April 2021 has already been paid. After such payment, when the petitioner seeks for release of bank guarantee and demands payment of the retained amount, the invocation is sought to be made to after more than 3 years from the supplies being effected. The series of events give rise to a prima facie doubt as to the conduct of the respondent 1. The invocation of the bank guarantee according to a prima facie view based on the facts of the instant case, unless a contrary view is established and discloses further facts, if allowed, will be permitted to respond unjustly enrich itself at this stage. One of 3 things on that fact. First, my lord, the liquidated claim damages, my lord, was secured. 2, my lord, it was after 3 years. 2, it is after 3 years. Thirdly, my lord, there was no claim for damages before this. So, my lord, this, my lord, with great respect, my lord, does not, my lord, come into, my lord, our facts at all. I'm not saying there's no dispute. Of course, there's a dispute whether, my lord, the purchase agreement, whether I've suffered damages or not, or whether, my lord, there is a, but all that, my lord, can't be looked at this stage. Guarantee, my lord, has to be, my lord, given, my lord, its full flow, and, my lord, invocation. So, my lord, his case that no amount due and payable under the purchase order therefore can't be invoked. That's, my lord, his case. Is, my lord, his assertion. So both, my lord, are cases, my lord, or arguments which he has to make before the learned, my lord, arbitral tribunal to be successful. That doesn't, my lord. This is the language for all. Now, the invocation, there were 8 invocations, right? 8.
So one invocation was done. So 2 for this, 2 for total, and 4
So, all 8 were invoked, no? So, 28 and well, this where will
so it's in the convenience compilation.
well, in the convenience compilation,
Yes.
Page 57.
well, we'll find page
58.
57, is it?
57 is the index, 58 is the
58. Well, is one of the letters. I'd made a note, my lord, with
page.
Well, 58. Invocation, my lord. One is 28 November. I'll just show my lord 2 more things, and my lord, I think, my lord, I'll be over. Invocation, my lord, is 28 November 2024 and also 29th November 2024.
Yes.
And my lord will find, my lord, we say terms of the sunset supposed to receive on 26th August, payment due didn't come on time. Now, since we have not received full payment against the overdue outstanding amount, payable is already overdue, and from the given incidents, it is clear sunset defaulted its commitment to make payment. Hence, we are forced to invoke bank guarantee, and my lord, we invoke it. Bank guarantee should be remitted. And my lord, these are all there, my lord, at then my lord, page 59, my lord, will find 29th November, my lord, the other invocations. So this was paid, no? So ICICI Bank, my lord, page 59, they agreed, my lord, to have, my lord, this remitted to us. Now, my lord, we'll see all of them are invoked saying that I have a claim. Now, with great respect, my lord, he is not to say that I don't have a claim. At least not, my lord, before the bank guarantee, my lord, authority. So that's one. And my lord, in the petition, my lord, again, my lord, subject to correction, just show me paragraphs 18 and 19. My lord, in the section 9 petition, I did not find that, my lord, there is any case. My lord, it's at page. Is it also in the compilation?
No, so it's in the main.
My lord, it's in the main. My lord, it starts, my lord, at page 29. It starts.
Page 29 of the application.
Application, my lord, the main revision petition, my lord.
Page 29.
Page 29, my lord, is his, my lord, section 9 petition.
Page 29. Page 29 is part of the grounds.
Huh? My lord, in the revision petition?
Yes, 4068.
My lord, my petition ends at, my lord, page 20. Is it not the right thing?
Sorry, 122.
Huh?
It's so 122 because.
So, मेरा page क्यों different आ रहा है?
No.
I'm sorry, with 122. I'm told. Oh, 122. Oh, yes.
That's it.
Sorry, my lord, 122. I'm sorry, my lord. The other page.
22 is section 9.
Yes, I'm so sorry, my lord. And there, my lord, will find, my lord, at page, my lord, paragraphs 18 and 19. Paragraphs 18 and 19, my lord, page 131.
18 and 19.
131. Paragraph 18. My lord, can you see paragraph 18 and 19? Because this is, my lord, the only ground I found, my lord, why there. However, to the utter shock and surprise, the petitioner received communication from the respondent's banker for invocation of bank guarantee on 28 November 2024 at 19:19 p.m. and 20:19 p.m. Such invocation is wrongful, fraudulent, and malafide in nature. Respondent number 1 has perpetrated egregious fraud upon the petitioner. Copies of such notices invoking bank guarantee annexed to collected marked with letter A. Petitioner further apprehends respondent numbers 3 or 4 are also proceeding to encash the bank guarantees issued by the other respondents. However, the petitioner has come to learn that similar notices have been sent for invocation. It would be evident from the perusal of the terms and conditions of bank guarantee that respondent numbers 2 to 4 would be obliged to pay the amount of rupees 8 crore to the respondent 1 merely upon a written demand being made. It would further be evident from a perusal thereof that the respondent numbers 2 to 4 can raise no dispute with regard to the amounts due and payable by the petitioner to respondent, as the purported demand made by the respondent 1 would have to be treated as conclusive. This is their statement. They are aware of what is the bank guarantee. Furthermore, the bank guarantee furnished in this regard have been drafted in such a way so as to unfairly prejudice the petitioner by giving a higher bargaining power and unfettered rights to the respondent 1 to invoke the bank guarantee. This is his pleading on which he goes to court. This is his pleading. And then he says, 20, as on 29 November 2024, amount of rupees 3 crore 97 is payable by the petitioner to respondent 1. Petitioner is always ready and willing to make payment, and the same has been communicated to respondent 1. However, by invoking the bank guarantees, respondent 1 is attempting to unjustly enrich itself to the extent of 8 crore against the total undisputed dues of 3 crore 97. Respondent 1 is therefore not entitled to invoke the bank guarantee, and the respondent numbers 2 to 4 are not obliged to act on the basis of such invocation. Then, as will be evident from a perusal email corresponding or WhatsApp message exchange between the petitioner and respondent 1, petitioner taken all steps to take payment. In fact, the petitioner, then kindly see, in fact, the petitioner has discharged most of its payment obligations and has been continuously making payments to the respondent 1. But I said bank payment was not being made through bank guarantees. They were making payment. This last time they did not. Then we invoked all the 8. And then it says, however, from the correspondent evident that for collateral purpose, the respondent 1 repeatedly pressurized the petitioner and threatened the petitioner with invocation bank guarantee by taking undue advantage, now let's see, of the unilateral terms thereof. Evidently, the intention of respondents to. Then, paragraph B also, will see what they say is egregious fraud. At page 133. B, they say we have no dispute with regard to payments, raising no dispute. They have not raised dispute. And then, on that basis, they ask for order of injunction. So, paragraphs 18 and 19, and particularly 19, will kindly keep in mind where they, in fact, they understand the bank guarantee as being unconditional, and they say it's one-sided. So, there should be no order, restraining, the arbitrator's order, should survive. That's my humble suggestion.
I will answer only 2 points because there is no reply to reply, but my learned friend has dealt with a case, cited a judgment, and he has for the first time drawn your lordship's attention to paragraphs 18 and 19 of the section 9 application. Now, if your lordship looks at paragraphs 18 and 19 of the section 9 application, what was that in the context of? That was in the context of the fact that you are trying to invoke bank guarantee of the value of 8 crores on account of price of goods sold and delivered of the value of 4 crores. Well, that is the context in which paragraphs 18 and 19 written. And if today one looks at paragraphs 18 and 19, then my lord, there can be no doubt that my lord, the bank guarantee my lord, clearly provides for, even my lord, in relation to the provisions of the contract, that is the purchase order, that my lord, if there is any amount that remains unpaid in respect of goods that have been supplied after a period of 30 days, in that case you can invoke. So my lord, what is the context in which paragraphs 18 and 19 have been written? It is written in the context of the fact that my lord, you have proceeded to take undue advantage of the language of the bank guarantee in attempting to, my lord, invoke bank guarantees of the value of 8 crores against dues only in the region of about 4 crores. My lord, one very, very important thing. Is that at that juncture, there was no, my lord, assertion of my learned friends having, my lord, suffered any loss and damage on account of non-acceptance of the goods under the so-called disputed purchase order. That came only much later in the affidavit in opposition or the written objection filed to the Section 17 application before the arbitrator. So, my lord, at this point of time, my lord, there was no scope of taking any objection in that regard, or, my lord, saying that the bank guarantee is conditional in the context of the fact that, my lord, it could not have been invoked on account of any claim for, my lord, damage allegedly suffered on account of non-acceptance of goods under a purchase order. That came much later. Now, my lord, your lordship has seen, my lord, in Hindustan Construction, in the Crest case, and even, my lord, in our High Court judgment in KSC Electricals, that, my lord, the court has looked at the contract to see whether the contract has been performed. And, my lord, even in, my lord, Hindustan, my lord, even, my lord, in Hindustan, my lord, Construction, the court has said that ultimately, my lord, one looks at the contract to see what? If it is performed. In that case, my lord, if you still intend to, my lord, invoke the guarantee and receive payment on the guarantee, that is iniquity. So, my lord, the courts have, my lord, not, my lord, put on blinkers. It is not, my lord, reduced to the position of, my lord, a vision so focused that one cannot, my lord, look beyond the tunnel. So, my lord, the courts have consistently looked at contract to see this was the obligation secured by the performance of by the bank guarantee. This obligation is performed. Is the other obligation on which account we are now seeking to enforce and encourage the bank guarantee, is it now secured by the bank guarantee? And, my lord, there reference is specifically made even in bank guarantee to, my lord, the performance of the contract. My lord, since my learned friend has placed so much emphasis on this, I'll just read one line of the bank guarantee, my lord. I'm sorry to trouble your lordships, but, my lord, this is extreme.
Can we have it on Friday?
Yes, my lord. Yes, we can do that.
17th.
Yes, ma'am.
I also may have some queries. In the meantime, I shall go through the papers. 17th will be in problem.
But then 16th, my lord, if it's possible, my lord. I'm so sorry.
A lot of matters because 20th to 28th, this bench might not be available.
Oh.
17th.
There are a lot of matters.
But here, this one. Well, I'm not there, my lord. I have, my lord. But
well, I have now consciously decided not to, my lord, take up so many outstation, my lord, matters. So, Mr.
But I've also consciously decided, but unconsciously, my lord, I sometimes, my lord.
16 তারিখে দুটো তিনটে সময় কিছু আছে
আমি আছি আমার 10-15 মিনিট 15 minutes 15
দুটো সময় না
হ্যাঁ
my learned friend really, my lord, replied to, my lord.
He has dealt.
Reply to rejoinder. I've dealt with your cases.
He has cited a new judgment. I'm sure
only one new judgment.
Yes, I'll distinguish it.
We can have it on 16th at 3. It won't be for long, I think.
No,
well, at 15 to 20 minutes max.
Just
15 minutes.
Anything more, my lord?
15 minutes.
I don't think I need to.
No, I'll not cite any new judgment.
Unless, my lord, there are any questions, my lord, from the.
Yes, there may be some. Because a lot of
17.
Because are there, I'll go through them and.
Well,
16. 17th, I also have a bench. I was just now informed.
16.
15.
Heard Mr. Banerjee, learned senior advocate, appearing for the petitioner. And Mr. Shaha, learned senior advocate, appearing for the opposite party number 1. For continuation of arguments list on April 16, 2026 at 3 p.m.
And, my lord, we are sorry, my lord, we are
On behalf of my lord, all of us, particularly my juniors, my lord, we are tendering my lord unconditional apology. I'm told my lord they mentioned and my lord wanted my lord to have it.
No, I told them that
My learned friends,
My lord, that my lord.
my learned friends very desperately want the money in their bank account, even if they can't
No,
use
I would desperately want the money under the invocation.
it. That, my lord, he
You're
has
lucky, my lord, we have not preferred my lord any appeal or revision from there.
my lord, there's an expression saying you don't push your luck too far.
Well, I don't know. I don't know, my lord. I would have, like, my clients didn't want to, that's it.
Thank you.